Kindly note serial number 27 in list number 1. But recently, I have filed wakalat for respondent number 2. I am not served the copy of the petition. It is available in the court file. If there is a direction, please highlight.
It's a big copy for the petitioners.
Proof of partition. Trial court without lack of judgment has found that I will like refer to land tribunal on the ground that whether the suit schedule property item number 4 is granted exclusively to the grantee therein or on behalf of the giant. No, my lord. The impugned order is at page number 284. My request to Madam to kindly peruse page number 284. 284. After hearing the arguments on merits and after going through the records of the case and the decisions under section 33 of the Karnataka Land Reforms Act 1961, I find it necessary to record the following. This is a suit for partition and separate possession. There are as many as 4 items of the properties. Item number 4 of the suit schedule properties, namely 2 acre 20 meters of land is survey number 130/3 of Dodbelangla village, Dodbelangla, Dodbelapur Taluk, with the description given in the Muttaya is one of the family member. The genealogical tree. Is it page 42? It is in Kannada. May I give an English? But these plaintiffs and defendants, parties herein are the descendants of one Chitana. Plaintiffs are there are in all 8 plaintiffs stated in there. First plaintiff is Ganganamala, who is the grandson of Chennappa. The plaintiffs and defendants herein are the descendants of Chikana. Please, madam. Please. It was granted in favor of Muttaya.
Yes, let's come back.
Yes. Please, madam. From the record of the case on hand, there is no material to indicate as to whether the rival parties have put forth their rival claims before the land tribunal of Dodbelapur as to whether the item number 4 of the suit property is granted in favor of the individual Sri Muttaya, or as to whether the item number 4 of the suit property is granted in favor of the giant family, in which Sri Muttaya is one of the members. There is no finding given by the land tribunal of Dodbelapur on said question. No, my lord. There was no question before the land tribunal. When Muttaya, my lord, admittedly, it is the Muttaya who has opted for the grant, and the land has been granted in his favor. To that extent, there is no dispute. No, but the present case before the trial court was whether the benefit of the grant inures to the family of the giant, inures to the entire giant family. Whether Muttaya is a member of the giant family and land granted to him, that benefit inures to the family is the question before the civil court. And admittedly, the land tribunal cannot grant the relief of partition. It is completely vested with the jurisdiction of the civil court.
No, ultimately, where is that? Where is the order? What is what the court did?
The above background, it would be apposite to refer the law declared by the Honorable Supreme Court in 2009 SEC 626 Initial Goda and others versus Mallikarjuna Gowda and others. Therein at para 13, the Honorable Supreme Court had ruled that
the documents are not before the court.
No, it was reserved for judgment.
No. Allotment in favor of Muttaya.
It was produced. It was produced.
What is the case of the plaintiff and what?
This case is this manner, there were in all 4 items. We are all members of the giant family. Plaintiffs and defendants are the members of the giant family. Item number 4 was granted in favor of the Muttaya.
That is the case of the plaintiff.
That is the case.
It is not the case of the plaintiff that being a member of the joint family, on behalf of the joint family, it is granted to Muttaya.
Yes, on behalf of the giant family, it is granted. Benefit inures to the family. Now the grant is not disputed. Once the land tribunal has passed an order saying that the Muttaya is the grantee, that has not been challenged before the civil court.
There is an order to that effect.
But the grant, we have admitted that it is granted to the Muttaya. There is no dispute to that effect. No, our contention is it the land granted in favor of Muttaya, that benefit of the grant inures to the giant family. If to prove that, my lord, we have to show that all these items are the joint family property. Necessary issues were framed to that effect. Evidence was available. Without considering, when the case was reserved for judgment, my lord, by relying upon the judgment of this court, my lord, the Honorable Apex Court, my lord, the trial court has found out that the matter has been referred to the land tribunal.
Not entire with regard to
With regard to item
whether
number
that property is granted to Muttaya in his individual capacity or as a member of the joint family. That's what the court wants to know.
Yes, yes.
So what is the difficulty?
Please, my lord. My lord, what's the land tribunal has granted, my lord, that so and so person is the grantee, my lord, he is entitled for the grant. Then that attains the penalty, my lord, unless there is no challenge to that order.
So, no, then wow, you are
What
saying
can I
that,
decide that aspect, my lord?
no, you are saying that it is not granted to Muttaya in his individual capacity. That's your case. The case of the plaintiff is,
My lord, though it is granted in his individual capacity, he is in possession, the artist is for in his name. My humble submission, my lord, is that the benefit of the grant inures to the joint family because he is member of our joint family. He is member of our joint family. It is not a contention that the land joint family was in possession. But it is like this, my lord. One of the joint family purchases a property out of this.
let's look at the issues that are framed. They are there here.
In this regard, my lord, I would like to rely upon the lecture of this Honorable Court, my lord. Wherein the coordinate basis of this Honorable Court has distinguished the issue of what has taken place.
No, that we'll go to that later. Let's understand the facts.
Please. Issues, my lord, page 37.
37. From the records on hand, there is no material to indicate as to whether the rival parties have put forth their rival claims over the land tribunal as to whether item number 4 of the suit property is granted in favor of the individual or as to whether the item number 4 of the property is granted in favor of the joint family in which Sri Muttaya is one of the members. There is no finding given by the lands tribunal on the study. When was this allotment?
Lord, absolutely, there was no rival claim before the tribunal. It was not the question before the tribunal.
When was the allotment?
It was during his lifetime, way back in the 1971.
1984.
The document actually does not.
So nobody is disputing that fact.
That fact is not disputed. And if one of the joint family member purchases the property, he says that it is his self-accord property. And the burden is upon the plaintiff to show that whether it is joint family property or self-accord property. That has to be decided by the Supreme Court. In similar situation. And granted in favor of Muttaya. Whether the benefit of the grant inures to the family or not, it's a matter of.
Where is that contention of yours?
Pardon?
Where is that contention of yours, pleading of yours?
Please.
In the plaint it is there. Please come to that.
Paragraph 4, page 22, my lord. Page 22 of the resolution, paragraph 4, my lord. The plaintiff submitted all the suit scheduled properties of the joint family properties of the parties to the suit, and they are common in position. They are in common position of all the members of the joint family and in common joint interest.
No, about the suit, item number 4.
Page. From the top, my lord, 4th line, in the next page.
That is 23.
From the top, my lord, it is further submitted that time. It is further submitted, all the suit scheduled properties are the joint family properties and the property bearing survey number 130, but that is the item number 4, my lord, which has been granted by the land tribunal in the name of Muttaya, who had filed the form number 7 on behalf of the joint family. It is not, my lord, there was no any rival claim between the members of the family. The plaintiffs are able to show that, my lord, on behalf of the joint family.
No, that's precisely when you're saying that is granted on behalf of the joint family to Muttaya, then the court has asked, is it so from the land reforms tribunal? What is that you're going to do?
For that, my lord, the trial court has to decide not based on the available evidence, my lord, what the evidence the plaintiffs are given. what the defendants has given, based on that materials, the trial court has the conclusion whether there exists a joint family between the parties, whether they are in joint possession. One of the member has filed an application, RTC was standing in his name, that was not disputed. Grant was not at all disputed. Tribunal get jurisdiction only when when it is to decide whether it is an agricultural land, whether the person who filed form number 7 is the tenant, whether he is entitled for the grant. That aspect has to be decided. Once it is done, the
It is
tribunal
your-
has not given any finding.
It is your specific case that it is not like how you are submitting now. It is your specific case that on behalf of the joint family, the grant is in favor of Muttaya.
Yes, ma'am.
Not that it is not your case that it is granted to Muttaya, but it will inure to the being a member of the joint family. It will inure to the benefit of the other members. That's not your case. So precisely court wanted to know, was it granted to him or to the joint family? What is wrong in it?
We are not stated that the grant paid in favor of Muttaya.
Look at it. You said it is in favor of the joint, as a member of the joint.
Rival claim, my lord. We have no any rival claim. What we saying, since he is member of our joint family.
That's not you're saying. You say on behalf of the joint family, it is granted.
It is what can be calculated in this, my lord. We say that all the suitable properties are the joint family.
If what is the prejudice to you now?
My lord, till now, my lord, this order is passed in 2016.
You have come before this court.
No, it is
And
requested
obtained
for-
stay.
From just 6 months I have filed NOC Wakalat.
No, that's what I'm saying.
I inquired, my lord, till tribunal is not constituted by the government. Tribunal is not constituted. And we don't know when it is to be constituted. And one more, my lord, kindly peruse the coordinate bench judgment. It's English. Relevant.
Yes.
No, I will skip the para 10 to 13 are relevant.
Para?
10 to 10, 12, 10 to 13,
Hmm.
but I stated on the 13 para. Para 13 is page 15 of the judgment.
Yes.
Because in other para, the relevant facts of that case have been. Para 13, my lord, as far as the contention of so and so, that the civil court has no jurisdiction to grant partition with reference to the judgment of the apex court in case of Ishwar Gowda Supra is concerned. It is to be noticed that there was no dispute before the tribunal when the form number 1 was filed before the tribunal. The dispute arose only after the grant of occupancy rights. In terms of the law laid down in aforementioned case, if the dispute is before the tribunal, then the tribunal alone gets jurisdiction to decide the inter-alia dispute among the rival claimants. However, in this case, that is not the position. There was no dispute before the tribunal. That being the case, the ratio laid down in the aforementioned case does not apply to the case.
Hmm.
Here also, my lord, it is not. We are not saying that, my lord, the land granted in favor of Muttaya is wrong. We are not assailing that order. We are not questioning that order. What we are saying, since he is member of our family, the land granted in his
But
favor.
that's not your pleading at all. That's not your pleading at all. Your pleading is something else.
My lord, we have stated it is joint family property. Then the burden is upon to show that whether it is joint family property.
No,
or
no.
not. If
Why
we
you
are
say that
unable
it
to
is,
prove that, my lord,
why you say it is a joint family property? According to you, the tribunal has granted it in favor of Muttappa being a member of the joint family, and on
we are all descendants of original propositor Chennappa.
it is further submitted that or the so and so, and the property bearing survey number has been granted with the lands tribunal in the name of Muttaya, who had filed on behalf of the joint family. That's the crux of the issue. What's wrong in it?
No, my lord. What we have stated is we are all descendants of one Chennappa.
According to you, that form number 7 is filed in the name of the joint family. That's what is your pleading.
Since he is a member of our joint family, we have no any rival claims.
What did the court say? Please come to that. Court only said whether it is granted on behalf of the joint family or in the individual capacity of Muttaya is only that's a limited question. Court wanted to know.
Civil court can itself decide that, my lord, saying that since the
All
land.
that material is not
There was
before
no
the
finding
court.
by the tribunal, my lord, that is the land granted is exclusively to Muttaya. There was no such finding that has been observed in impugned order. There was no finding that the land which was being granted to Muttaya has been granted to him exclusively.
Then I'll record that finding. I'll record that that's a submission that that the property is granted to Muttaya, but it's your contention that he is a member of the joint family that inures to your benefit also. And there is no dispute that the property, the grant is exclusively in the name of Muttaya. Shall I record that?
Yes, ma'am. Please, ma'am. Let them read.
The Where is the page number? The agreed with the order dated
It is dated 6/10/2016.
6/10/2016,
I'm sorry, madam, 31/8/2016.
31/8/2016,
2016.
whereby the civil court had referred the matter to the Land Reforms Tribunal that there are two questions involved in the case. They are whether the jurisdiction of the court to entertain the partition suit, B, the jurisdiction of the court to decide two conflicting issues of fact, whether the occupancy rights in respect of item number 4 of the suit property is granted in favor of the joint family in which Sri Muttaya is a member, or whether the occupancy rights in respect of item number 4 of the suit property is granted in favor of Sri Muttaya in his individual capacity. The court, relying on the judgment in Gopalakrishna versus K. Bashir, reported in 2016 3 KCCR 2398. The court felt that the issues have to be decided, have to be referred to the Land Reforms Tribunal for its decision. And only after the decision of the Land Reforms Tribunal regarding the said rival contentions, then the court can go into the question of partition. Agreed thereby, as the matter is referred to the Land Reforms Tribunal, the plaintiff is before this court. Land counsel appearing for the plaintiff submits that the entire matter was heard, and when the matter is posted for judgment, at that point of time, the court at suo motu had referred the matter to the Land Reforms Tribunal. He submits that the judgment that is relied on by the petitioner, by the court, the judgment that is considered by the court do not apply to the facts and circumstances of this case. It is submitted that it is never the case of the plaintiff that the grant is in favor of the joint family, but it is a case that though the grant is in favor of in favor of Muttaya, but he being the member of the joint family, that endures to the benefit of the joint family members. It is submitted that after it's a suit of which year?
2008.
A suit of 2008. 2008, and at the fag end, the court had passed this order. It is submitted that whether they are entitled for partition or not, whether partition or not, and all other material, even the records of the tribunal, or even the grant that is in favor of Muttaya are all part of the record, and the court can independently decide the same. And for that reason, there is no necessity to refer the matter to the Land Reforms Tribunal, and the Land Reforms Tribunal cannot pass a decree of partition. Next paragraph. On 28/1/2025, this court had heard the learned counsel for the petition in part, and there was no representation on behalf of the respondents, and directed the matter to be listed today under the caption parted. Today also, there is no representation on behalf of the respondents. Next para, having heard the learned counsel for the petitioner, there is the entire material on record. It's a suit for partition. There are four, how many? There are 4 items. And in that, the 4th item is the occupancy rights were granted in favor of Muttaya, who is one of the joint family member, and the grandfather of the defendants.
He is one of the descendants, the original proposal.
That's what grandfather, he is a grandfather of defendant number 1.
One.
Grandfather of defendant number 1. But the court, it appears from the record that the matter was heard and reserved. And at that point of time, court has opened the matter and referred the matter to the Land Reforms Tribunal to find out whether the grant is in favor of Muttaya or in favor of the joint family. When it is the case of the plaintiff that the property is granted to Muttaya, and if they say that it is not in favor of Muttaya, but for the, but for that the form is filed in favor of the joint family, then the burden lies on the plaintiff to prove the same. And the land counsel appearing for the petitioner submits before this court that it is never their case that the form number 7 is filed in the name of the joint family. And it is not disputed that the grant is in favor of Muttaya, but he being a joint family, member of the joint family, it endures to the benefit of the family. In these circumstances, in the considered opinion of this court, it is not necessary to refer this matter to the tribunal, and the burden always lies on the plaintiff who claims that to be a joint family property. In that view of the matter, the order dated so and so is set aside, and the tribunal, the civil court the trial court shall decide the matter within a period of 2 months from the date of receipt of the copy of the order. Next matter.
Cell number 2, K. Shivakumar, for petitioner.
For the petitions.
Finally, the day has come. Yes,
2017 to 2017.
no, not only 2017, after that it has come up before me so many times. Yes, use the mic.
That's the petitioner has filed the suit for the relief of fair injunction. That suit came to be decreed after contest. That subsequently by the defendants, that is the judgment abettors, they are disobeying the order of the court. Subsequently, execution petition came to be filed. The execution petition notice had been issued to the
When was
defendants.
the judgment and decree?
The judgment and decree in the year to second, 2/9/2014.
29?
2/9/2014. That subsequently, immediately after the decree, they have started interfering with the possession of this the petitioner. That's a complaint came to be filed. Subsequently, when they have not taken any action, those several complaints have been registered against them. Finally, to execute the decree, execution petition came to be filed in the year 2015. Execution number 16/2015. In the execution petition, the notices have been issued to them, but though they are residing in the very same address, but they have avoided. Finally, we have taken the paper publication. Then, the application came to be filed seeking police protection. Then, on the same day, they have appeared before the court and filed the application to set aside the ex parte order passed in the execution petition, and permission they have sought to contest in the execution petition. Then, the trial court, without considering the application filed by the petitioner, dismissed the application only on the ground that the civil court has no jurisdiction to grant the police protection to the petitioner, that is plaintiff's property. So that the order has been questioned in this present writ petition.
What do you
But
say?
the Supreme Court has also said one judgment.
Who
Yes.
grant police protection then?
No, once, the impugned order is not like that, Milord. May I read the body interface?
Page number?
80
80?
84.
Earlier occasion also they approached the dishonorable court, Milord. Dishonorable court has observed in the writ petition. Kindly peruse, Milord. Earlier order passed by the dishonorable
No,
court.
we'll read this and then we'll go to
Please,
the.
please, Milord. May I read, Milord? Order on IA number 151 of CPC seeking police protection.
Come from Perusa records.
Please, Milord. Third argument, the decree holder. Peruse the record. It is execution petition filed by the decree holder for the execution of a permanent injunction decree against the judgment attached. In the said petition, the present application is filed and the relief of police protection is sought to the decree holder and his property. It is vehemently argued by the advocate for the decree holder, pointing out the instances mentioning in the affidavit annexed to the application that the Judgment debtors continuously disobeying the decree passed in favor of the decree holder on the basis of the said grounds sought for the relief of the police protection. Also argued that under section 151 of CPC, the court has.
So the
inherent
court
powers-
said for granting police protection to the person, court has no jurisdiction.
Yes, minutes.
Number one. Then when it comes to the property, now
They
the
already announced the execution for-
ex
for
parte
court.
ex parte order is set aside in the execution petition.
They need to
I know
notify
they have
back to the
come,
court
they
of
have
court.
come on record. Then the court has to decide whether there is any violation of the order or not.
By giving evidence before the executive court.
No,
That is the
minutes,
settled law.
151 minutes in so provision is concerned, minutes 21 rule 35 is minutes, there is a specific provision. Though we have filed the application 151, it has to be considered. Evidence is not required insofar as to grant the police protection is concerned. Minutes, there are materials available on record, minutes with
For
regard to,
that, the
let
court
the-
has to understand.
please minutes.
Has to understand.
But minutes, we have requested the trial court because so many materials, minutes, all the complaints have been filed.
Court to decide it. What is now, what?
Decide, minutes
You
within,
know, what is the relevancy of it of 2017 now?
yes, minutes, but still it is pending.
The question
Because-
is, they are not-
No, minutes, no.
The order sheet is-
Minutes.
that.
They are avoiding, minutes, they are now not appearing.
Sorry.
Minutes, they have not appeared before the trial court. This is the way, minutes, since even in this present writ petition, minutes, they are avoiding to appear before the court, even before the trial court,
Simultaneously, both of you. can't
even
answer.
before the trial court. Because continuously, because now they are violating so many complaints. Additional documents have also been filed. Number of complaints have been
What
lodged.
we'll ask is the trial court to decide this IA,
Yes,
this petition of yours within 1 month.
yes, minutes. Please, minutes.
Please come.
One more submission.
Considering all the documents and the complaints filed by,
This way back in page
No.
84 itself. This is for non prosecution. Now he is pressing that he got the stay order from this, there was no stay. Instead of proceeding with the executive court, he prolonged from all these 9 years. Now he is coming that it has to be decided within 1 month. And earlier order kindly produce order passed by the sample
Yes.
court below. May I produce for a moment below?
I have produced
This
the
was
copy.
shown by the petitioner's hearing law. This one could have observed in the earlier order application law, in terms page 68 for a moment below. Annexure G is the earlier order. passed by
Anyhow,
the
we'll
sample
put an end to this. The agreed with orders passed on I number IA file under 151
One
CPC.
more below, the 151, court has no jurisdiction to pass giving police protection. That is settled law by the apex court and also by the.
Whatever is the wrong,
by the-
quoting a wrong
provision is-
provision, quoting a wrong
Is-
provision of law is
There
not the
specific
issue.
provision. Inherent powers can be
Let's-
exercised under 151. That is
Then
the-
the court will quote that and do it.
But Supreme
the-
Court has said in this judgment.
The agreed by the orders passed on IA under 151 CPC seeking police protection, the decree holder, petitioner, the petitioner decree holder is before this court. The petitioner has, what is the order date?
Order dated 7.
Unfortunately, all the orders, we have to search for the date,
Yes. 4/7/17.
2017.
4/7/2017. The petitioner herein has filed a suit for injunction and that came to be decreed by judgment and decree dated 2/9/2014. On the ground that the judgment debtor is interfering in spite of an order, in spite of a judgment and decree granted by the court, he has moved an application under 151 CPC seeking police protection to the property as well as to the person. Initially, an ex parte order was passed by the court. Thereafter, on an application filed by the plaintiff by the judgment debtor, the same came to be set, the said order came to be set aside. Thereafter,
There was no expert order, my lord. It was not noticed,
No.
the notice was not served on.
9 Rule 7 application has been filed in the execution petition to set aside the expert. That has been allowed in the execution petition.
the court, by order impugned, has observed that the court has no power to grant protection to the person. When it comes to the properties, the court is already,
The last paragraph, page 84.
Petition is filed and it is under consideration. The remedy
No,
of
not that.
violation of
After
police
3 lines, decree holder is out of the purview of the civil court. A civil court cannot order for protection of, does not warrant the exercise of
that is
this.
with
That
regard
is
to the
wrong.
person.
Person is concerned, but the,
As
so
a
far as
judgment
property is,
debtor number 1 to 4 and 6, replace ex parte on the basis of substituted service of paper publication as they are necessary parties to the present petition. they're also entitled to have an opportunity to stay in the matter. Then, first of all, this writ petition has to be, I think on cost it should be dismissed.
That's a difficult thing.
What is that wrong with the order and why you have been protracting the litigation from 2017? Are there any bona fides on the part of the petitioner?
Let's so many, with
Not
regard,
so many. The
let's-
court said, as far as the protection to the person is concerned, I cannot grant.
Yes.
What is wrong in it?
but
And
property,
when it comes
let's,
to this, the court said, there should be an opportunity for the court, just like that you ask for police protection, court will grant.
but that application has been dismissed. Let's, without considering that, that application has been, does not warrant.
Execution has to be decided, the main execution petition has to be decided. Unless and until that is decided, how can there be an interlocutory?
It's in the
application grant?
execution petition when we have sought for police protection because continuously there is a breach of an order, I mean,
But
the
there should be-
decree.
For
Let's-
that, there should be some evidence, some order.
So many documents have been produced before the court. So many FIRs have been registered.
What did you
Because of
write?
that
What
reason,
did you-
let's, we have filed the execution, I mean, application.
Huh? No. The defendant number 1 to 4, 1 to 4 and 6. For place ex parte, right? That 1 to 4 and 6 for place ex parte on the basis of substituted service by paper publication. Comma, as they are necessary parties to the present petition, they're also entitled to have an opportunity to say in the matter. Hence, the court felt that there appears to be a good cause for their non-appearance, and accordingly, application filed with the judgment debtor is allowed on cost of rupees 1,000, placing the judgment debtors number 1 to 4 and 6 by setting aside that order. The court has also observed that as already the execution petition is pending, at this stage, application for, unless and until the same is decided, the application of the decree holder for police protection cannot be considered. Next para, agreed with such order, the plaintiff is before this court. Then counsel for the petitioner, the petitioner decree holder submits that when the judgment debtor is violating the judgment and decree passed by the court had failed to grant police protection and had dismissed the application while setting aside the ex parte order passed by the executing court. It is submitted that unless and until police protection is granted, it would cause a lot of hardship to the plaintiff. Plaintiff judgment decree holder and all these aspects were not considered by the court. Then counsel appearing for the respondent judgment debtor submits that when the execution petition itself is pending, question of granting police protection in an application filed under 151 is not maintainable. He submits that when there is a specific provision under the CPC, he cannot maintain application under 151 and cannot invoke the inherent powers of the court. It is submitted that the court had rightly considered and passed the order or passed the order. Next para, having heard the counsels on either side, there is a material on it. Yes, for the judgment, the decree holder has filed the execution petition. Initially, the decree holder, the judgment debtor is set ex parte. Thereafter, application is filed to set aside that order, and the court had set aside it on cost of rupees 1,000. Pending execution petition, the petitioner's application for police protection cannot be considered by the court, and the court has to consider the execution petition itself. The finding of the court on that aspect is perfectly correct, legal and valid. Then coming to the police protection sought for the person, as rightly observed by the court, there cannot be any police protection to the person. Considering all these aspects, this court is of the view that the order passed by the court do not warrant any interference from this court. Accordingly, this court is passing the following order. Considering the fact that the judgment and decree is of 2/9/2014 and the execution petition is filed in the year 2015, the main execution petition itself shall be disposed of within a period of 3 months from the date of receipt of the copy of the order, placing on the material placed before the court.
It's one submission. Supreme Court has said during the pendency of the execution petition, it's 151 application, but with regard to police protection, it has to be considered. It's what the recent, this the application has been filed minutes under section 151 of CPC. Minutes the trial court has dismissed by invoking the wrong provision. Subsequently, minutes the apex court has said, minutes the execution court can be considered.
It is about quoting a wrong provision of law is the judgment.
Yes, minutes.
This court is not on that point.
But minutes in the execution petition, question of minutes granting the police protection, that has also been considered by the apex.
You filed the execution, you are seeking execution.
Yes,
effect.
it's execute.
And according to you, you seek police protection for so and so reasons. They are before the court.
Yes.
They are before the court. That has to be considered by the court.
All these the
Will be
documents
considered,
and
everything will be considered your execution.
by the executing court.
Yes,
It's
next.
within-
Then number 3, case of CA for petitioner Mohammed Farooq.
What is that?
Suit for declaration.
What happened to two? This is two. One is so, yes. Three.
Appearing for the petition, my lord. Suit for declaration and consequential.
Yesterday also no representation? Were they there yesterday? There is no representation on behalf of the respondent, yes. Yes.
Suit for declaration and consequential relief of injunction, my lord.
Hmm.
Plaintiff is petitioner is the plaintiff before the trial court, my lord. There is an agreement for sale between the defined number 1 and defined number 3, my lord, on 21/3/2007. Thereafter, GPA was executed by defined number 1, authorizing to sell the property in favor of defined number 3, my lord. Defined number 3 has sold the property to this petitioner, my lord. After this sale deed, my lord, the defined number 1 has settled the property in favor of defined number 2, who is his wife. Settlement deed was executed in his wife's favor, my lord. His wife sold the property to defined number 4. The facts were not known to this
One and
plaintiff,
two are wife and husband.
my lord.
1 and 2 are wife and
Yes,
husband.
my lord.
Hmm.
Defendant number 1 and 2 are the wife and husband, my lord. There is
So
settlement.
defendant number 1 executed a deed in favor of defendant number 3.
Sale deed, agreement to sell, my lord, in favor of defendant number 3. And
He has
GPA,
executed in your favor.
yes, my lord.
Hmm.
Defendant number 3 sold the property to me.
Thereafter, defendant number 1 has settled the property in favor of defendant number 2.
Defendant number 2, my lord.
Hmm.
Defendant number 2 sold the property to defendant number 4, my lord. I have filed declaration that
When is your sale deed?
my sale deed is on 17/12/2007.
17?
12/2007, my lord.
Hmm. Hmm.
And agreement is on 21/3/2007 in
Hmm.
favor of defendant number 3.
Hmm.
And GP executed by defendant number 1 in favor of defendant number 3 is 23/4/2007.
23?
4/2007.
Hmm.
Settlement deed in favor of defendant number 2 on 8/10/2007, my lord.
Hmm.
Defendant number has purchased the property on 7/1/2008, my lord.
That is in favor of D4.
D4.
Hmm.
D2 sold the property to
You
D4.
filed the suit in the year?
2008
Hmm.
for declaration and consequential
This
injunction.
IA now.
IA for regarding the payment of court fee, my lord. I have paid the court fee under section 26C of KCF and SV Act that is valued at 1,000, and I have paid the court fee as rupees 25 rupees, my lord.
Hmm.
May I read the operating portion, my lord? Is it 12, page number 12?
Page number?
12, my lord.
Hmm. Come here. This is yes.
Admittedly, the plaintiff is not the party to the said settlement deed dated 8/10/2007, executed by the defendant number 1 in favor of the defendant number 2. In the settlement deed, there is no recital with respect to consideration. The plaintiff paid the court fee as per section 26C of KCF and SV Act. Though the plaintiff has prayed for the declaration of settlement deed is binding, it is not binding actually. You have prayed that it is not binding on me. On the plaintiff, it amounts to a cancellation of the instrument. Therefore, the plaintiff has to pay the court fee as per section 38 of KCF and SV Act. The learned counsel for the defendant rightly pointed out that the plaintiff has not paid the court fee as per section 38 of KCF and SV Act. The learned counsel for the defendant has further argued that the court has no peculiar jurisdiction to try this suit, my lord. That is, this aspect will keep open. It will be decided after the plaintiff valued the relief as per section 38 of the KCF and SV Act. Therefore, for the reasons reference and discussions made herein above the following. Plaintiff is hereby directed to value the relief as per section 38 of KCF and SV Act to pay the proper court fee. There is one judgment, my lord.
Which case? Charu Singh's case.
Yes, my lord.
Is here. Where are your objections?
My lord.
Where is your on this court fee, where are your objections to that?
Orally argued, my lord.
Hmm?
Objections are not filed. I was sought for only declaration regarding that
Where is the
plaintiff is annexed. Page 14, my lord.
page?
Page 14, annexure B.
Relief.
Relief is at page 19, my lord. Last but one para. For a declaration of decree, the registered settlement deed dated 8/10/2007 executed by the defendant number 1 in favor of defendant number 2 and registered as document number so and so in book so and so of sub-register of Mangalore City, Mangalore is null and void. And next, for the relief of payment as a permanent injunction restraining the defendant number 2 from alienate or disposing of the plaint A scheduled property on the basis of fraudulent registered settlement deed dated so and so, registered so and so of the office of the sub-registrar Mangalore City, Mangalore. This relief is
You're
being
seeking, you're seeking cancellation of the sale date. And it
Null
has to
and-
be on the, that it has to be on that.
Null and void, I am seeking.
That's what. That's the difference between the judgment and this case. Because you're not an executant, you need not ask for such relief. But you sought for that.
Yes.
It has to go, your petition, please come. The agreed with orders passed in on the preliminary issue with regard to the court fee. The plaintiff is before this court. The plaintiff has filed a suit seeking a declaration that the register settlement deed dated 8/10/2007 executed by defendant number 1 in favor of defendant number 2 and registered as document in the sub-registrar's office, Mangalore City, is null and void, and also sought for a relief of permanent injunction restraining the defendants from alienating or disposing of the property on the basis of the fraudulent registered settlement deed. When the defendants have raised the issue with regard to the pecuniary jurisdiction and also on the court fees. That the court by order in June had directed the petitioner to pay the court fee as per section 38 of the KCF and the C Act. And then counsel appearing for the petitioner submits that as he is not an executant of the document, he need not pay the court fees as per the he need not pay the court fees on the market value of the document. With the court, and he can pay the court fees. He can pay the fixed court fees, and all these aspects were not considered by the court. Next para. Then counsel appearing for the respondent, defendant submits that in this case, the plaintiff had sought the relief of cancellation of the relief that the to declare the document as null and void, and as such he needs to pay the court fees on the market value of the as per the value mentioned in the document. In his case, he relied on in petition, he relied on the judgment of the apex court in case of Shivrup Singh versus Randir Singh and others reported in AR 2010 Supreme Court 2807. Having heard the counsels on either side, there is a material on record. The judgment relied on by the court petitioner in case of Shivrup Singh do not apply to the facts and circumstances of this case. Here it is not the case of the plaintiff that is not binding on him. The document is not binding, but the relief that is sought is that to declare the settlement deed as null and void, and in that case, he has to pay the fee on the court fee on the market value of the said document. In that of the matter, this court finds no reasons to interfere. Dismiss.
Then number 4. For petitioner, Shiva Prakash, correspondent.
I pay for petition.
Yes,
I had completed my argument, sir. Once again,
unfortunately, I don't remember it. Yes. What is the issue?
regarding the I had filed an application under section 28 of the strict relief act, rescission of the contract,
Yes, that with regard to that,
5,000.
now I remember the fact. Yes, yes. Please come to that relevant portion in the order. Dates, give the dates.
Yes.
When is the suit?
Agreement is on 5/2/1989.
Please pass on. That's on two.
Agreement is on 5/2/5/1989.
Oh,
Total sale consideration is 30 lakhs. 25,000 has been paid. 30,000, sorry, 30,000.
hmm,
25,000 is paid and 30,000 is the total consideration.
oh,
Suit is filed on
hmm,
7/4/1992.
hmm.
Suit came to be decreed on 30/11/1998.
30/11/1999. 99 or 98?
98.
You're given it as 99.
30/11/99. Suit decreed with cost of 3,158. 30/11/98.
90?
98.
I think that needs to be corrected.
I'm sorry, 30/11/1998.
You have mentioned it as 99. Yes. Hmm.
Thereafter, I had filed an appeal.
Hmm.
Appeal came to dismissed on 13/10/2005.
13,
Sorry, 13th.
30/11/1998, suit dismissed.
Yes.
What is
Thereafter,
the
I
suit,
preferred
sir?
an appeal. RA.
No, before that, there is a suit, OS number 248.
Yes. Ag-
Subsequent purchase.
One suit is by the
I think instead of looking at it, please tell the dates. Yes. So agreement dated
2/5/1989.
2/5/1989.
1989.
A suit is
Suit is for specific performance.
filed on
7/4/1992.
hmm,
Suit came to be decreed on 30/11/1998.
30/11/1998. Hmm.
Operative portion, page number 83 of the order is
Operative portion is that page number?
83.
Then thereafter, what is your appeal RA number?
In RA number 24 of 1999.
Dismissed on 13/7/2005.
13/7/2005.
Hmm. Hmm.
23
Hmm.
23/2006 execution petition is filed by the respondent. In execution petition number 10 of 2006,
Hmm. Hmm.
where I had filed an application for rescission of contract under section 28 of Specific Relief Act on 24/11/2014.
24/11.
2014.
Hmm. Till such time, the remaining amount is not paid.
Not paid.
Uh,
From the day 1, 1989,
Right from 2006 till you filed, they have not
No.
paid. Even till now, it is not.
it is
paid.
not paid.
Hmm. Hmm.
Order of the trial court at page number 141.
Page number?
141. And typed page is at 150.
Yes.
Shall I read from page number 156?
Yes.
Shall I read? Upon hearing the agreement on both the sides, agreeing there is a dispute as to passing of the decree in OS number 268 of 1992, dated 30/11/98, along with the respect to the regular appeal filed in JDR in RA 24 of 99. It is the contention of the JDR that the DHR has not deposited the balance sale consideration even after the dismissal of the appeal by the first appellate court, and even after the expiry of the appeal period to this second appellate court. And the DHR has filed an execution petition on 33/2006 without depositing the balance sale consideration amount. And also the decree is silent about the outer time limit within which the plaintiff has to deposit the balance sale consideration amount as per the section 28 of Specific Relief Act. The execution petition is liable to be dismissed.
Hmm.
It is the contention of the DHR after the contest.
You were relying on certain judgments on
Yes.
that day. Where are they?
Yeah.
Court officer?
one regarding TL Rajagopal.
What is that? TL Rajgopal.
TL Rajagopal.
Hmm.
Another one is Prem Jeevan.
Which para in TL Rajgopal?
TL Rajagopal, para number 13 and 17. 13, 17, 23 and 25.
20?
3 and 25.
Let's read that.
I shall read para number 24. The subject matter of the suit is in moved property situated in Tiptur town. The value of the moved property situated into towns and cities in multiplying the every year. The plaintiff decree holder who had to benefit of the decree also has to benefit of having the 2,85,000 with him for 14 years, and he did not have and seek any extension of time to deposit the said amount. Today, if the courts went to direct to dependent to judgment deposit to execute the sale deed, for consideration of which they should be have to be paid received 14 years ago, it would cause a great hardship and irreparable loss injury, as the said amount would be not value at all. In that view, the matter contract of the sale requires to be rescission, and consequently, the degree of specific performance is required to be annulled. Where the contractor is rescission in under subsection 1 of the section 28 of the Act, the justice of the case requires to be the court to be proved under section 28(2)(b) of the Act for an order of refund of the sum paid to a vendee or lessee as the earnest money or deposited in the connection being
Sir,
connection.
then it come to Shyamala's case. Which para? Para number 24.
Para number 24. Shall I read? Applying the law laid down by this court in the aforesaid decision, the fact that the case on the hand is considering the section 28 of the specific decree, we are of the opinion that the trial court erred in exercising the discretion in favor of the plaintiff and erred in extending the time in favor of the plaintiff to deposit the balance sale consideration of rupees 15,000, 15 lakhs by condoning the huge delay of 853 days, which the observations is herein have been explained sufficiently as in observed or in above. The plaintiff was directed to deposit the balance sale consideration of rupees 15 lakhs within a period of 2 weeks from the date of the ex parte judgment and decree on 12/10/2003, when the plaintiff failed to deposit or pay the no application for extension at time under section 148 of CPC and the section 28 of the specific request was made thereafter within a reasonable time, was made after a period of 853 days. Nothing is on the record that between the any of notice was given to the defendant to execute the sale deed as per the judgment and decree or on the deposit of the balance sale consideration. The application filed by the plaintiff under section 148 of CPC, section 28 of Specific Relief Act seeking extension of time to deposit the balance sale consideration was hopelessly delayed. As observed herein above, section 28 of the Specific Relief Act seeks to provide a complete relief to both the parties here in terms of the degree of the specific performance. Therefore, the trial court failed to exercise the discretion judicially in favor of the defendant or erred in exercising the discretion power in favor of plaintiff, to which the delay of 853
Other
days.
judgments also.
Yes.
We'll hear the senior counsel. Yes,
Another one is the Prem.
that I have seen, yes. Yes, yes.
The last day that it had secured the lower court records. Now, the London Council has secured it. There are a lot of points to submission and brief notes are there.
Yes.
I had not received the copy.
But
it's an application filed under section 28 of the Act. Kindly see mirror section 28 for a moment.
Yes.
Decision in certain circumstances of contract for the sale or lease of immobile property. The specific performance of which has been decreed. Where in any suit, a decree for specific performance of a contract for the sale or lease of immobile property has been made, and the purchaser or the lessee does not within the period allowed by the decree. In the decree itself, it should show that it should be paid within particular time allowed by the decree or such further period as the court may allow. My lord, firstly, the decree should say that you have to pay within a particular time. Or, my lord, subsequently an application must have been filed and the time has been extended. Otherwise, my lord, this section 28 is not applicable. May allow pay the purchase money or other sum which the court has ordered him to pay. There should be a specific order of the court to pay the amount within particular time. The vendor or lessor may apply in the same suit in which the decree is made to have the contract rescinded. And on such application, the court may by order rescind the contract either so far as regard to the party in default or altogether as justice. My lord, kindly see, as the justice of the case may require. My lord, ultimately your lordship has to see whether injustice has been done to the other party. If the delay, if there is no order passed by the court or extended by the court, and the decree specifies that this amount has to be paid within particular time, these three consequences are not there, then the court has to see whether justice of the case requires that the agreement or the decree is to be honored. That's the section 28 says. My lord, my learned friend has heavily relied on the judgment. I will come to the facts of the case later. I will clarify the judgment first. The judgment, my lord, of this court is fully in my favor. And it is an ex parte decree passed, my lord. Therefore, while considering the equity, the court has said, now this money is paid, nothing can be purchased. Years have passed. Therefore, this is 28, my lord, they have exercised the jurisdiction. I may be permitted to read. Firstly, it is an ex parte decree. It is not the contested decree. Specific relief act. My lord, can I take your lordship's page 20? When the plaintiff has to do, if the defendant will not to obey the decree passed by the court, is therefore clearly spelled out in the judgment of the trial court. The plaintiff was given the liberty to take steps to get the sale deed executed and registered to the court by depositing the balance sale consideration after the time prescribed for filing the appeal expire. In the decree itself, it is there. You have to deposit the amount after the expiry of the period. He has not complied with that order. Therefore, the court has said, you have not deposited the money within the time granted by the court. Therefore, exercising power under section 28 is proper. Unless there is a direction to deposit in the decree itself, to deposit the amount within particular time. Suppose the party is not in a position to deposit. He files an application for extension of time. My lord, during the extended period also he doesn't deposit. My lord, third this thing is, my lord, though the order itself will say, after the period of appeal, you have to deposit. These are all in the order itself. When there is no such an order, whether, my lord, you see, section 28 is applicable or not is the short question that your lordship has to consider. Now, my lord, the next paragraph, the para 24. The subject matter of the suit is an immovable property situated in Tipsur town. The value of the immovable property is situated in town and cities in multiplying every year. The plaintiff decree holder who had the benefit of the decree also had the benefit of having 2,85,000 with him for 14 years, long years, and did not even seek extension of time to deposit the said amount. Today, if the court were to direct the dependent judgment debtor to execute the sale deed for consideration, which he should have paid 14 years ago, it would cause great hardship and irreparable injury, and the said amount would be of no value at all. In that view of the matter, the contract of sale requires to be rescinded, and consequently the decree of the specific firm also requires to be annulled. My lord, this is the reason, my lord, what the background of the case is.
Yes.
Where a contract is rescinded under subsection 1 of section 28 of the Act, if the justice of the cause is required, kindly see, my lord, the justice has to be considered. The court can provide under section 28(2)(b) of the Act, order the refund of the money. So, my lord, that's not a very relevant thing, my lord. Now, my lord, coming back to the facts of the case.
Yes.
Now, your lordship may kindly please to see the application filed by
Yes. Page number.
122.
Yes.
Application, affidavit 123.
Yes.
Lord, the earlier para 125 are only not degree passed and all these things. Para 6, my lordship may kindly please see page 124.
Yes.
Without prejudice to my earlier contention taken in the suit and before appellate court and in these proceedings, I submit that though I have denied the execution of the sale deed dated 2/5/1998, they firstly, my lord, see the conduct also. He has denied the execution of the sale deed first in favor of the decree holder. As per the finding of this honorable court, the execution of the sale agreement was proved. Now, as per the judgment and decree passed by this honorable court, the decree holder has to deposit the alleged balance sale considered amount before this honorable court immediately after the expiry of the appeal period. My lord, whether such an order is there in the decree or not, your lordship has to look in. And I will come back to that. But till today, neither the decree holder.
So if
nor-
such an order is not there in the decree, when the amount has to be paid, the decree holder can pay it at his
But
convenience.
execution of the petition.
Execution is filed in the year 2006.
No, execution of the sale deed. Normally, that is the practice. The decree will be passed and the certain amounts are paid, the balance amount is there is no order in the decree, that there is a direction to execute the sale deed by a particular time. During the execution of the sale deed, balance amount will be paid, that is the practice.
Yes.
Section 28 is an exception. Because there is a specific order, you have not followed that order, then, my lord, the cause of action to file section 28 application. Here there is no order. And what is the balance amount? Balance amount is 5,000. The appeal and the suit has been dismissed with cost. If you deduct the cost, it is 1,900 and odd is the amount balance to be paid. 600. And the petitioner and my lord, the respondents are brothers. And the my lord, the person who has for the 20 years late, earlier the land was given to him. He has made it fit for cultivation, struggle. And my lord, because he is a brother, he has not filed application under the Land Reforms Act. Other form number 7 filed, he would have got the ownership at that point of time itself. And he has entered into an agreement, which received 25,000 rupees. 5,000 was the balance. And the moment my lord received, the agreement was entered into, and he has taken 25,000. Immediately he sells the property in favor of his wife. Then wife says, I am the owner. When we have made her as a party in the suit, then she sells the property in favor of 2 persons. And when the decree has been passed, they have filed under 21. 2197, 2 application, 2 purchasers. With all this, my lord, the conduct of the other side, we have obtained the decree. And my lord, for the sake of 600 rupees to be payable. Now, an application under section 28, without considering the equity, if the contract is rescinded at this stage, whether it is in the interest of justice or not, my lord, your lordship has to consider. That's the only point. The judgment, my lord, 2 judgments were ex parte judgments, and the court has considered the equity, not that you have not paid the amount. They have considered the equity. Large amount was not paid, and that amount was not paid about 14 years back. And now that amount cannot be purchased anything, therefore they have passed an order. Now this is not the case here. Now, my lord, next, my lord, para 7. Appeal period. My lord, only ground they have stated amount of this honorable court expire of the appeal period. Now, your lordship has to see whether the appeal period is mentioned in the decree or the orders of the court, that you have to deposit the amount after the appeal period. If there is no such order, there is no obligation. I have not violated the court's order. If there is, my lord, yes. Then your lordship may kindly find out, my lord, whether such a condition is there or not. Admittedly, the appeal period, second appellate court has expired on so and so. The decree holder have filed the execution petition on 23/2006 without depositing the alleged balance sale consideration. My lord, only thing my lord has to find out, my lord, whether there is any order of the court after the appeal.
You know, that the decree is silent on that.
That's right.
Yes.
It is not there. No such order. Then,
Yes.
my lord, para 7. I submit that though there is a specific direction, order, there is no specific direction or order or time limit with regard to the deposit of alleged balance sale consideration amount of rupees 5,000 by the decree holder in a judgment and decree passed by the honorable court, and silent as to the outer limit within which the plaintiff should deposit the balance sale considered amount from the date of decree. The decree holder shall deposit the alleged balance sale considered amount immediately after the expiry of the period. My lord, this is what the affidavit says. They admit there is no order. but they ought to have deposited.
Yes.
Whether it is, my lord, is sustainable or not, my lord, it is for your lordships to consider.
Yes, yes.
But the decree holder has not deposited the same either before, along with the execution petition, and failed to comply with the decree. Where is the question of, my lord, I am failing to comply with the decree? I have not failed complying with the decree at all. Under these circumstances, the alleged contract of sale agreement needs to be rescinded and cancelled, and the decree is not executable in view of section 28 of the specific Railway Act, and the execution petition is liable to be dismissed, and consequently, the decree for specific performance also requires to be annulled. Hence, I am filing this application. I submit that filing of the application at this stage is not intentional or deliberate, but for the bona fide reasons stated above. I further submit that no harm or prejudice would cause to the other side if the application is allowed. On the contrary, I would be put to irreparable loss and hardship if the application is rejected. To good case in that. But I have filed my statement of objection kindly received. Page 128. Para 3. It is pertinent to state that the above said order, the appellate court directed the decree holder to deposit the balance sale consideration of rupees 5,000. But there is no time limit to deposit the above said balance consideration before this honorable court by the decree holder. After dismissal of the above appeal, the judgment letter not come forward to execute the registered sale deed in favor of the decree holder and not obeyed the order passed by the honorable court. In that circumstances, the decree holder without alternate remedy filed a present execution petition to obtain the sale deed from this honorable court. In the meanwhile, kindly note this, my lord. In the meanwhile, judgment debtor sold the above said property in favor of Sri Lakshmi Lal and another, and Solomon Raju, my lord, during the pendency of the appeal, lispendence, they have sold the property without knowledge and information of the decree holder. The judgment debtor played fraud on the court as well as to the decree holder. The honorable court be pleased to take cognizance and initiate criminal proceedings. It is submitted that after sold the above said property to the above said persons, the said persons filed application before this honorable court under Order 21 Rule 97 CPC. The honorable court of hearing the matter dismissed the two applications and oversight one of the application is pending before this honorable court. In these circumstances, the applicant and judgment debtor taking advantage filed the frivolous application on one or other reason only to protract and prolong the above said proceedings to misguide this honorable court and to harassing the decree holder. It is submitted that the above said application filed by the judgment debtor alleging that the decree holder not deposited the balance consideration of 5,000 before this honorable court, hence dismiss the execution petition by annulling the decree for specific performance passed in favor of the decree holder. It is pertinent to state that judgment debtor till today not executed the registered sale deed in favor of the decree holder, and also the honorable court not executed the registered deed in favor of the decree holder. In these circumstances, so and so. My lord, the written argument is fine, my lord, it is almost same. Both the page 136 for a moment.
Yes,
My lord, the second paragraph, page 136.
yes.
Further held that decree holder has to deposit the balance sale considered amount on expiry of the appeal period.
Yes,
He has also seeks extension of time and court may grant extension. In case of failure judgment debtor can make an application under 28 of the before the court which passed the decree or an execution petition which is nothing but continuation of the suit. In view of the above decision, the application filed by the applicant is maintainable and the question of decree holder executing the sale deed does not arise. And though the decree is silent about the outer limit, kindly see, my lord, it is according to the particular appellant itself. The deposit of the balance sale consideration in the decree holder shall deposit the same immediately after the expiry of the appeal period. But in this instance case, that was not done by the decree holder well in time, and the application filed applicant is not, it's maintainable. But your lordships have seen that there is no such condition in the
Yes,
decree or the appellate order that you have to deposit them after the appeal period.
yes.
Now the question is, my lord, whether non-deposit of a small amount. Six, my lord, kindly notice, 609. Synopsis, we have stated that 693 rupees to be payable during the execution of the sale deed. Whether, my lord, when there is no violation of the order, whether 28, my lord, application is maintainable to annul the agreement and decree passed, my lord, after so many years of fighting the period. And, my lord, so many, my lord, applications filed by the other side, selling the property one after another. Wife, then wife sells to third parties, my lord, filing application under 21. All these things, my lord, ultimately court has passed a decree. Whether, my lord, for this small amount, following the judgment is also, my lord, I am repeatedly saying that it is in my favor. That was an ex parte decree. The court has considered the equity in that case. Here, if the court considered the equity, it is in my favor. And, my lord, again, my lord, I want to read another paragraph of the judgment of this honorable court for the clarity. Para 10, my lord.
Yes.
Per contra learned counsel for the plaintiff decree holder arguing in support of the impugned order submitted that as no time is fixed in the decree, the decree holder, after passing the decree, issued notice expressing his readiness and willingness to pay the balance sale consideration amount. In this case also, my lord, I have given two notices
Yes.
saying that I am ready with the money. Please execute the sale deed. I have issued two notices, consideration and obtained the sale deed. When this request was not exceeded, the decree holder was constrained to file the execution petition within 5 months, which conduct clearly demonstrated that he was ready to perform his part of contract. The execution petition was stalled by the judgment debtor by filing application after application through his daughter-in-law as well as the son for the which the decree holder cannot be blamed. In fact, the decree holder has deposited the amount on 14/7/2011 original suit itself, as is clear from the provisions of section 28 of the Act. In the light of the above said facts and rival contentions, the point that arises for my consideration in this treatment, whether the application under section 28 of the Act is maintainable on the original side or in the execution. My lord, this issue we are not concerned because, my lord, ultimately the earlier the argument was whether it should be filed in the suit or execution petition.
Yes.
The court has considered it can be filed either in the suit or in the execution petition because it's a continuation of the suit. Then para 30.
Yes.
Not, one word I may want to point out to the lordship. Para, para 28, last paragraph, in which the decree is made to have the contract rescinded on such application, the court may, by order, rescind the contract either so far as regard the party in default or altogether as the justice of the case may require. That's the principle, my lord, your lordship has to consider. Wherein the contract is rescinded under section 1, the court shall direct the purchaser or the lessee if he has obtained, my lord, para 30. Therefore, to invoke the above provision, the person who has obtained the decree for specific performance ought to have failed to pay the money or other sum which the court has ordered him to pay. Unless there is an order passed by the court and I have failed to pay the amount, then, my lord, the jurisdiction under section 28 can be invoked within a period allowed by the decree or such further period as the court may allow. In such an event, the person who has suffered the decree has a right to apply to the court in the same suit in which the decree was passed to have the contract rescinded. On such an application being made, the court may by order rescind the contract either so far as regards the party in default or altogether as the justice of the case may require. Justice of the case may require.
Yes.
Once such an order of rescission of contract is made, the court shall direct the purchaser, the lessee, if he has obtained the possession of the property in the contract, to restore. The question is whether application under section 28 of the Act is to be made in the same suit, my lord, that's not necessary in this case. Para 80, specific performance being a discretionary relief, the court has ample power to do the justice between the parties. If any one of them were not to act in terms of the decree, as that the contention that the application under section 21 of the Act ought to be filed in the said suit, not in execution, my lord, it's also not necessary. Then para 20, my lord, I have read again, my lord, to conclude in this thing. What the plaintiff has to do if the defendant were to not obey the decree passed by the court, that is, court is therefore clearly spelled out in the judgment of the trial court. The plaintiff has given the liberty to take steps to get the sale deed executed and registered through the court by depositing the balance sale consideration after the time prescribed filing the said appeal period. My lord, that is in the order itself, decree itself, appeal period. Now my learned friend has said the appeal period is over, therefore they have not deposited, therefore the 28 is maintainable. There is no order at all. In the case in which, my lord, this honorable court has considered that aspect of the matter, has said that there was an order. He has not followed it. Therefore, my lord, the court has passed an order. Here there is nothing. And kindly see, my lord, I have filed the synopsis. Kindly see the, my lord,
Yes.
2589, my lord, is the defendant Malligachari offered the land measuring 1 acre 30 guntas for consideration of 30,000. Executed and signed by the agreement, 25,000 I have paid, my lord, on the date of the agreement itself. My lord, why? Yes, he is my brother only. Legal necessity for defendant is for completion of a newly built house in Bangalore. He was started constructing a house in Bangalore. He had the necessity of funds. He has offered the land, my lord, itself. Even prior to this, my lord, to 20 years, I was in possession of the property and cultivating. That's in the evidence.
Yes.
9191, legal notice by the plaintiff demanded to register the sale deed and receive the balance. 91 itself, I have given a notice. Please receive section, but the 5,000 and enter into an, the sale deed. 120392, again, my lord, I have issued another notice.
Yes.
There is absolutely no reply for these two. In the meanwhile, my lord, he has sued in his wife's favor. Suit was filed on 7492. Sale deed executed petition in favor of his wife Shantama. In 92 itself, he has sold the property in favor of his wife. Written statement by defendant known to alleging fraud. Suit decreed with cost of rupees 3,158. Decree silence in the matter of payment of balance amount. OS number 258 filed by Srimati Shantama for permanent injunction. His wife, my lord, on the Shantama, suit dismissed. RA number dismissed. Execution 10 of 2006 filed on 23/2006. Sale deed by the daughter of the defendant in favor of Solomon Raju. This is second time, my lord, they have sold the property.
Yes.
Sale deed by the daughter of Malligachari in favor of Nandala, that is on 110/2005. Nandala. 17/8/2000, the application under 21 rule 97 to 105 by purchase Nandalal, Someman Raju, numbered IA number 2 and 3. IA filed under order 21 is dismissed. My lord, there are two applications. One application is still pending.
Yes.
IA 2 and 3 filed under 21 dismissed. RA number filed by the Nandalal dismissed on IA number 2 and 3. Application, then my lord, the application came to be filed under section 28 of Specific Relief Act. My lord, I have been instructed to say till 24/11/2014, the judgment debtors have never appeared in the court. Cost of the defendant in the trial court is, my lord, 3,158. Cost in RA is, my lord, about 1,149. Total will become 4,307. To be payable, my lord, is 693, only 690. Memo filed in the trial court by decree holder expects into balance sale amount, no response. Death of the plaintiff Shardama, death of Malligachari, the defendant first and sold the property in 92. Second sale is on 1/10/2005. The conduct of the defendant in creating third-party interest by 3 sale deeds and in the year 2014, the application is filed in 22 of Specific Act that the ADR has no right on the property and the application as such is not maintained. Kindly see, my lord, on this point, the judgment debtor says he has sold the property. And the subsequent purchaser, wife also says she has sold the property in favor of 2 persons. Once they have sold the property, they have no right in the property. They can't say that, we are the owners of the property, we have to execute this sale. What right they have? They have already sold the property by registered sale deed. The decree has been passed by the court. The court has to execute the decree through a court commissioner. Where is the right to the, my lord, the defendants? Absolutely no right. They have sold the property to third parties. And where is the question of at this stage coming and filing an application under section 28? To annul the, who are they? I am asking this question to myself. Who are they? They are nobody. Now at this stage, my lord, can the court, considering the equity, can pass an order allowing the application and revoking the, my lord, the entire judgment and decree and agreement. That is, my lord, it is certainly not in the interest of justice and equity, which your lordships has to consider.
Want to respond? Reply?
Only page number 98 in first applied court judgment.
My lord, only one thing, my lord. Only one. My lord, we have also filed a memo that's in the record for original record to deposit 5,000. We have taken, I will told that your lordships have asked what steps you have taken. We have filed it.
When was it?
This is, my lord, 24, 3/2018.
After the impugned order.
Pardon, my lord.
After the impugned order.
After 2018.
Yes.
Page number 98 in first applied court judgment. Page number 98.
Yes.
Last two lines. This appeal is filed by me.
Hmm.
Therefore, the appellant is under the obligation to execute the sale deed in favor of the plaintiff. Plaintiff, respondent number 1, by receiving the remaining balance sale consideration amount of 5,000. It's there. There is first applied court. There is
No, you have sold the property.
that is before the
No, you sold the property in favor of your wife. And
first
you
is
had sold it in favor of third parties.
oh,
As of now,
but
there is
before
nothing-
filing up, before passing of the decree, one sale is there. That has been after the decree. It has been
Another sale, two sale deeds. Now, what is your interest in this now?
where sale deed is executed by the third party. First instance at the sale agreement which has been executed that had been challenged in this specific performance deed.
How can
Oh.
you execute a sale deed when there is a decree of specific performance?
Where
of
at the
wife
instance of the
And your wife is a party to the proceeding. It's an equitable relief, specific performance. And as you know, the conduct of the parties,
Yeah.
that assumes significance.
Where it has to be, there is a decree, it has to be binding on the parties.
Will pass, at 2:30 will pass orders in the court. Yes, next one. Yes, sir. Yes, next.
Cell number 5. Balgangadhar GS for petitioner, Ravi HK.
Yes.
My lord, yesterday, apologies, my lord, I was just on my legs.
Yes.
My lord, my only grievance is this JDR's writ petition, my lord. And my lord, the order for police protection is past ex parte. That should not have been done, my lord.
Let's see that. Let's see the impugned.
Please, my lord, the impugned orders is at my lord. The decree is for declaration and injunction. My lord, annexure D is the order sheet.
Number.
Please, page number, my lord, it starts from 45, my lord. The application is at my lord 21 rule 32. And also another application they filed under order 21 rule 22. And my lord, it's the order is passed, my lord, on 6/2/19, page 46 and 47. My lord. 46, my lord, the 21 rule 22A is allowed and cause notice was dispensed. Later, my lord, 21 rule 32 is ordered. Immediately, police protection is given. My anxious submission is this, my lord. Even though the notice, the cause notice is dispensed with, my lord, before ordering the police protection, the question of disobedience or other way, merely on the case of they filing a complaint will not arise. An opportunity should have been given to me. Therefore, my lord, the honorable court stayed the stay of that order.
There are two orders passed, my lord. The first order is dated 6/2/2019 at page number 44. Lord, why this
44 is
order
not an order, it is some affidavit.
Page 44.
It is some affidavit. Affidavit
45.
41 to 44 is there.
45.
45 is the impugned order.
In the previous page, 6/2/2019 order. Order on IA. Lord, why this order, the executing court dispensed issuance of notice to the judgment debtor because the execution petition was filed within 2 years after the decree was passed. This order is not challenged by the petitioner here.
That's by way of impugned order.
No, it's a separate order. It's a separate order. Separate order. This order of dispensation of notice to the judgment debtor is not questioned here. What is questioned is the ordering of police protection. He cannot have any grievance because this order, this judgment and decree of the trial court, my lord, has attained finality. He has not questioned it. Now, if he disobeys the
No. Please come to your application. What is your application? Page number.
40 mile. Annexure C mile.
You are narrating so many facts. So what is the difficulty? They're heard.
absolutely no prejudice to the judgment debtor because he suffered a decree is not questioned it. Now, if police aid is granted to the decree holder, he will not be put to any prejudice, my lord, because it is my property that is protected by way of a decree. And if police aid is granted because of his interference, no prejudice whatsoever to the judgment debtor. If he is not interfering, he will not be put to any hardship. He is only making out a case only to keep the dispute alive, my lord. Otherwise, absolutely no prejudice to him if police aid is granted, because I approached the jurisdictional police before making the application. They issued an acknowledgement saying that this is a civil matter, approach the competent civil court for execution of the decree. I made execution petition within 2 years.
No.
He has chosen not to question
No,
the decree.
instead of dispensing notice to the JDR, if he had heard, was he heard before it, what is the prejudice to you?
Lord, if execution proceedings are initiated within 2 years,
Not necessary.
notice can be dispensed.
Yes.
And having not questioned that order, he cannot say that no, I am not heard in the matter. If he had questioned that order in this petition, that would have been a different aspect. He has not questioned the dispensation at all.
Yes.
My lord, that may not be necessary. My humble submission is this. When 32, rule 32 is precedent to service, my lord. Now the prayer here is, my lord, kindly.
For example, there is a judgment and decree.
Yes, my lord.
Court, because you are unsuccessful in the appeal.
Yes,
or you
yes,
have
yes,
not
my lord.
preferred the appeal,
Arya was
and
pending.
it has attained finality.
Please.
The court has to execute the decree
Definitely,
in whatever manner it is.
Yes,
Ah.
but my lord, 32 may kindly be perused. They want that order to be passed for the police protection. My submission is, before that, whether there was any violation or not, my lord, execution, my lord, I can understand if it is a specific performance decree, commissioner will be appointed, we will apply for the recall or the sale deed cannot be executed. So many things I can file. Here is a case, ex parte, my lord, it is nothing but granting the final order itself. This, my lord, in any case, my lord, my humble submission.
Now, what does it mean that if as the decree, the
My lord.
execution is within 2 years, notice is dispensed with?
Yes, but
then-
that will not help him give the power, my lord.
What is required is notice according to you.
No, my lord. Inquiry should have been done also. 32, my lord, your lordship may kindly peruse. 32 rule 5 also, your lordship may kindly. That is for decree for specific performance or for injunction or conjugal rights. Where a decree for specific performance, that's not, or for an injunction has not been obeyed, not been obeyed. My lord, that thing, my lord, arises when, my lord, an inquiry is done. This is my anxious submission. My lord, if that is not done, my lord, dispensing is the powers, my lord. Dispensing, my lord, even my submission is, if I come and say before the honorable court that should not have been done, show cause notice had to have been done, then, my lord, 22 prescribes that within 2 years it is there. Well, but the 32, the rigor of the 32 rule 5, my humble submission is, has not been obeyed. The court may, in lieu of addition, all or any of the process, direct that the act required to be done may be done so far as practicable by the decree holder or some other person. No, but before that, my lord, preceding is that, my lord, has not been obeyed.
What ultimately the court is going to do?
Yes, my lord, whether I have obeyed or disobeyed.
Court is going to execute the decree.
Yes, my lord. That execution is, my lord, when, my lord, my humble submission is, his allegation.
No, even as, no, how are you affected? Ultimately, you say that I have not disobeyed.
Yes.
Disobeyed the decree.
My lord, for that, my
Court is saying court is only executing the decree.
No, my lord,
It has to execute.
no, my lord, before that, my submission is, unless, my lord, they prove that there was a disobedience. This is very important. Kindly has not been obeyed. This is what I want to bring it to your honors, your lordship's consideration. If it is done, my lord,
Ultimately, result is one and the same.
my lord, result maybe my humble submission is, if the honorable, if I am able to substantiate before the trial court that it could not be, we have not done any disobedience.
No, how can you tell the court that the decree need not be executed?
No, my lord, can't say that. My prayer is, I have not disobeyed. Then, my lord, this one becomes infrastructure. Suppose, my lord, what happens? Your lordship may kindly appreciate 39 rule 2A, my lord. That situation, it's with regard to the interim orders also. Now, in the similar way, 32 rule 5, my lord.
It is execution of the decree.
No, my lord, when execution, my lord, the word is, my lord, kindly, my lord, 5 may kindly be perused. Where has not been obeyed. My lord, merely on the basis of an allegation of complaint or police complaint, my lord, it doesn't mean that, my lord, there is an obedience.
In that case, what should have been done?
My lord, an inquiry should have been done.
How?
My lord, notices should have been given to me. I should have been given.
One hand, you say that notices can be.
No, my lord, on this application, my lord. This application, my humble submission.
The whole purpose of filing is only for this application.
Definitely, my lord. But the question remains, unless, my lord, this is considered, my lord. On this application, my lord, should have been considered. This is my submission.
Please come. Agreed with the orders passed.
If even, my lord, my one more submission, my learned friend said, no prejudice will be caused to me. My lord, there may be an allegation straight away that, my lord, I have disobeyed. Now, my lord, this will also come in my way to prove my innocence in the entire proceedings itself. That's why, my lord, that
What he is seeking is execution of the decree.
My lord, that is to be considered only, my lord, after considering both the opportunity.
It has to be executed. You have no.
It will be. It will be. I not say. But the question is granting the ex parte, my lord. This is my. That's why, my lord.
What they have done, they have given a police protection for executing the decree.
Please.
It has to be executed.
My lord,
if you're not coming in the way, then there is no problem for you.
But the question is, my lord, the disobeyed, my lord, it is predetermining.
To the technicalities. Yes, agreed with the orders passed in execution number 11 of 2019, dated
4. Dated, my lord.
6.
6 to 19, my lord.
6.
6 to 19.
6 to 19.
Please.
Whereby the court has allowed an application around 21 rule 32(5). Let's say at this section 151 CPC. The judgment debtor is before this court. The respondent herein was the decree holder has filed a suit for injunction.
Declaration injunction.
Injunction that came to be decreed by judgment and decree dated.
Please. My lord, 1/4/2017.
on 4/2017. Thereafter, the, he has filed the execution number 11 of 2019. In that, as this application is, execution is filed within 12 years. No, within
2 years.
2 years. 2 years, he has filed an application to dispense with the notice to the judgment debtor, and the same was ordered. Thereafter, the court had passed the order. The court observes that in the present case, it prima facie reveals that the JDRs are trying to interfere with the possession of the decree holder or the petition scheduled property. Hence, if the police aid is granted in favor of the decree holder, no prejudice will be caused to the JDR. Since if the application is allowed, no prejudice would be caused. Further, the court felt that it is necessary to direct the concerned police to provide police aid in favor of the decree holder to protect his possession over the property, and accordingly passed an order allowing the application filed under Order 21, Rule 32(5). Agreed thereby, the decree, the judgment debtor is before this court. Learned counsel appearing for the decree judgment debtor submits that the judgment debtor submits that as far as dispensation of notice is concerned, as the execution is filed within 2 years, he has not agreed with that order. He has drawn the attention of the court to Order 21, Rule 32(5), submits that unless and until there is disobedience and unless and until an inquiry is conducted by the court cannot pass such an order, and definitely it would cause prejudice to the judgment debtor and the court without considering all these aspects and without even an inquiry whether there is any disobedience or any interference by the judgment debtor has passed this order. Which needs to be interfered with by this court. Next, then counsel appearing for the respondent judgment decree holder submits that the decree holder, the judgment debtor has not questioned the order whereby notice and the execution petition is dispensed with. And without questioning that order, he cannot question this order. He submits that he is the decree holder and the decree, judgment and decree has attained finality. And the judgment debtor has no other option but to obey the decree passed by the court. The court has rightly observed that no prejudice is caused to the judgment debtor by passing this order, as there is a decree in favor of the decree holder which has to be executed. He submits that there are no grounds to interfere with the well-considered order passed by the court. Next part. Having heard the counsels on either side, there is the material on record. The undisputed facts are that in a suit for declaration and injunction, the suit is decreed and that judgment and decree has attained finality. According to the decree holder, as there is an interference from the judgment debtor, he has filed an execution petition. He has given a police complaint, and as the police have not interfered, he has went before the civil court and filed the execution petition. In that, he has sought for dispensation of notice as well as police protection. The court had ordered dispensation of notice to the judgment debtor as the same is execution is filed within 2 years from the date of the decree. Then it comes to the order. Admittedly, there is a judgment and decree which has attained finality. Now, the decree holder wants the execution of the same. How the decree or judgment debtor is agreed with such an order, the court is not able to understand and appreciate. If any third parties are affected by such order, they have their own they have their own remedy. And as far as the decree holder, the judgment debtor is concerned, he has no other option but to obey the decree. In the order that is passed by the judgment by the trial court, this court do not find any reasons to interfere accordingly. The petition is dismissed.
My lord, one observation, my humble submission is, any recording of findings with regard to interference by the trial court or by the honorable court should not come in the way of final dismissal. That observation I humbly submit.
As far as this court has not observed anything,
Anyhow, endorsing.
any of the, if
Please,
any
my lord.
observation.
Only a prima facie finding that is
it
given.
is-
Yes, my lord.
it
That's
is
why, man. I am
Basing on the observations either by this court or by the trial court
Please.
with regard to the interference is based on the assertion of, based on the case of the decree holder. And it shall not come in the way of the judgment letter.
To decide the case on merits.
Huh?
On merits. On merits to consider the case on merits.
Which
If
case on merit?
this matter, my lord, they will conduct the evidence now. My lord, disobedience, they will bring it to the notice and that should not be taken.
Consider the case on the merits of. the
Please,
case.
please. Much obliged.
Number 6, Prasanna BR for petitioner, Chidambar GS for respondent.
Yes.
I appear for the petitioner defendants manner, respondent plaintiff. Plaintiff has filed a suit for bar injunction. I number 2 for not to put up the construction over the suit scheduled property. Trial court it was allowed. We have filed the MA. There also the lower
Confirmed.
appellate court has confirmed this.
What happened in this case? In the writ petition, any order? In the writ petition, any interim order?
No, my lord. No interim orders.
Let the court proceed with the matter.
My lord, I have one.
So, when is the injunction that is granted?
4/8.
16/12? Now we are in 2025. 3 plus 5, 8 years. He has been enjoying the injunction in his favor. Now why would
My
we
lord,
interfere at
we are
this
in
point of time?
We are in the possession, my lord. Admittedly, we are in the possession. 80% of the construction work is already finished, my lord. Only roofing 20% is remaining, my lord. And also, my lord, we are ready to take the memo of undertaking that we are not claiming any equitable relief if we are allowed to put up the construction, my lord. Because if we,
Let's look at the order. Order of the appellate court. Is it recorded by the court that already 80% of the construction is completed?
yes, my lord, in
Huh?
page number 48, para 13, my lord.
Hmm.
The learned counsel for the appellant has stated that already construction is going on and ultimately he will abide by the judgment of the case and he will not seek equity.
No, where are the constructions according to you?
My lord, we have produced the photographs, my lord. Before,
Where are they?
it's before the trial court, my lord.
You want to complete another, that 20% of the construction?
Yes, my lord, because we have put a lot of money on that. If in this stage only building will be there, then it will damage the roofing, my lord. It will collapse at later stages, my lord. We are not claiming any equity, my lord.
File an affidavit and the photographs.
Yes,
Then we will see what order needs to be passed. So we copy on them.
Two facts not subsequent to filing of this petition. And claiming that he is the legatee under the will by my mother. And filed a P&A which came to be allowed. And I challenged that before the Assembly court in evening. That was allowed, my lord, and the matter was remanded back. And this suit, 31 of 2017 filed by me.
No, this is,
Also transferred to my lord some other court.
no. Now the issue is, if the defendant has completed 80% of the construction and that he will not execute, he will not create any third party rights and he'll not claim any equity. Let them complete the 20% of the construction also. What will happen?
Then last 7 years, my lord, it is.
No, that's why, let him,
Dispose of within, my lord.
no, let it be continue 20% of the construction. If it is, if you succeed, then you will be the beneficiary. Then there will be a rider saying that he'll not execute, he'll not create any third party rights. File an affidavit.
Yes,
But the next date of hearing, when can you file? Let counsel, huh?
2 weeks. Madam.
Counsel appearing to the petitioner submits that already 80% of the construction is completed. In fact, they have stated even before the trial court that they'll not claim any equities or create any third-party rights. If the construction is stopped at that level, it would damage the structure. List this matter on 5th of March. By the time the affidavit shall be filed before this court. Yes.
Number 7.
Your Lordship, appearing for the petitioner in this case.
Yes.
Last date on 7/1.
Hmm. The child is having exams till 25/1.
Please, Lord.
The street directed to furnish a copy of the mediation report dated to the council so and so. Have you looked at that?
Yes, my lords.
Hmm. Yes. Where are those reports? What are your submissions on this report?
Your Lordship, at paragraph number 1,
Hmm.
she is very comfortable with her mother. I couldn't see that same bonding shared with her father.
Hmm. Where are you reading? Which date
First
is-
paragraph, third line,
No,
Your
no,
Lordship.
which date?
Report date itself.
It is the third page, my lords.
There are so many, 3 reports.
My lords, one difficulty is there is no date.
The report starts with what?
As per the Honorable, to the Director, Karnataka Mediation Center, Bangalore, observation report of case WP 658 of 2023. This is the same thing in every report. As per the Honorable Court of Karnataka, orders in
2012
WP on 2012-2024. Aparna was asked to see her father. That is the first paragraph, my lords.
Yes. Yes.
On that, the third sentence onwards, I was
Hmm.
reading.
Hmm.
She is happy child, smiling and talking, and I observed that she is very comfortable with her mother. I couldn't see that same bonding shared with her father. But Ajay kept saying, that is a respondent, that her earlier visits were much of fun and laughs. Over the time, Aparna has changed a lot in her behavior, especially during this visitation. Now, on 22nd paragraph, my lords, on 21st December, Aparna met her father, Ajay, in front of me. Aparna was much better in responding than her last meeting. She and her dad interacted and did some crosswords puzzle and viewed some pictures and videos of earlier visits to her father's place. I appreciated her and kept talking to interact and respond to her father. Third paragraph. The next meeting was on 23rd. Aparna was very reluctant, not at all interested to talk or even look at her father. She had complained to her mother that I had forced her to talk on 21st December. Though it was a nudging, from my end, Ajay was happy to spend some time with her. On this day, she just put her head down, and when I asked her to see and talk, she said, "Ma'am, I don't like to spend my holidays like this in court." Very disheartening to see this child respond like this. Even then, she somehow spent her time till 1 p.m. And fourth paragraph, the third meeting was also spent as the earlier one. As soon as she entered the room, she just put her head down and didn't respond to my call or her father. She didn't respond to any crossword games or videos or photos. It was clearly indicating that she was forcefully made to sit and talk. Later off, the meetings were called off as Aparna was unwell and had her winter vacation got over and her school was resumed back. During these meetings, I kept encouraging Ajay to have interaction with Priyanka concerning Aparna. But Ajay is not comfortable in talking to Priyanka and the vice versa. Child hesitation to visit her father during this phase is a multifaceted issue rooted in emotional, psychological, and environmental factors. Both parents can help ease the transition for child and preserve the relationship between her and the father through open communication, emotional support, and a commitment to creating a safe, stable environment, which will be crucial in helping child overcome her hesitation and adjust to the changes brought on during the divorce procedure.
Yes.
Your Lordship, there is no such kind of a bond is due to various reasons. July 2019, respondent left the petitioner and child. October 2019, he left for China. And December 2019, he informed that he will not be returning to India for 5 years. And January 2020, the petitioner, without any other remedy, has filed for sole guardianship. So there was no contact for 2 years, except a few phone calls and some Amazon gift delivery. February 2022, the respondent filed an IA for access to child. So for 2.5 to 3 years, he was not bothered to see the child who was in the early stages of the childhood, which was some 4 years, 5 years like that. At that time, he has abandoned her. And April 22, court granted 50% of summer vacation. And he was exercising that. And even May 2022, full month, the child was with Ajay or the respondent in Kerala. But June to October 2022, when he was exercising his visitation twice a month, this period, 8 to 10 times, he has taken the child to the pub. And this, in spite of the child stating that I don't like my father to come home drinking and that smell itself, I don't like. In spite of he stating that I will not repeat it next time, he was doing it repetitively. And November 2022, he has filed for vacation access, Christmas vacation. And December 22, the child appeared in the trial court and said about the alcohol consumption and her discomfort. So the court has ordered 3 days visitation in the court premises itself. Out of that 2 days, the father has had the visitation rights, but the 3rd day he didn't come. And January 2023, we approached this honorable court, and this honorable court has granted a stay. And in January 2023 to April 2024, no action has been taken by the respondent to vacate the stay or do something for this one. Instead, April 2024 only, he has come forth again for vacating the stay by filing an application on 15th of April. And then your lordship has had the visitation interaction with the child, and it has come to intermediate supervisory vacation by this honorable court's direction and order, and also by the child counselor. Your lordship, what I would suggest at this point of time is a supervisory visitation, that too not for 3 hours, might be 1 to 2 hours for weekends, maybe up till the exam starts, the annual exam starts. And then probably when the bonding is happening, it can be increased to 3 hours or 4 hours like that. This is what my suggestion and opinion would be, your lordship.
If I may just point to the one line that the counselor has mentioned here. That's, I think it is at the last para. Third line, she had complained to her mother that I had forced her to talk on 21st December. Now, definitely the child would not have come and told the counselor that I went and told my mother that you forced me to talk to my father. This must be the mother coming and telling the counselor herself. Now, everything, the child is made to go and report to the mother as to what happens during the visitation. That is the main concern in this case. Earlier, when there was half a month granted, the child was extremely happy, as could be seen from the photos, my lords, which I have produced with my objections. Extremely happy. And what they are speaking about, the restaurant, it's not a pub, it's a restaurant where liquor is served. And I think most of the restaurants nowadays where non-veg is served will have liquor. And it is with the family that he has visited.
Yes.
And the family friend's daughter is also extremely close to the child. I have produced all those photographs.
So that's on one side, how you want the rest of the.
Going
further-
ahead, yes, my
further-
lords, that is the
further-
main thing. It is more than what past has occurred. How we are going to go in the future is the crux of the matter here. Let's supervised
Suggestion
visitation.
was that, what do you say?
Let's not supervised visitation. In fact, the respondent father is okay to bring his mother wherever, whichever place. In fact, during the times of mediation that has happened or the talks, many times the child has expressed to the father, can we go home? Recently, I'm talking. Can you take me home, Acha? She has asked. But he has not taken because that was not the order of the court. She has removed him from the school portal. He has no access. And in fact,
Yes, Mr. Counsel, what do you say?
Your Lordship, can you take me to my home? It is not his home. It has been twisted and put for that to his home. It is not his home. And also the photographs, if your Lordship looks, only the respondent is showing all the teeth and he is happy, not the child. Entire teeth can be seen by the respondent in all the photographs, but the child is not that happy.
Why he shouldn't show?
No, he can show. But who is more happy has to be seen, your Lordship. I'm not telling he should not show
I
happiness.
would say the child is happy. She's extremely happy in this. With him,
He
with
is
his
not
media.
happy, but
Please get instructions from your client. We will dispose of this matter and there won't be any supervised visitation. The father can spend time along in the presence of the grandmother will also come and he'll have the visitation
Yes.
once in a week and we'll dispose of this writ petition with that order.
please, your Lordship, in that case, maybe her classes should not be.
No, that's why I'll put this matter tomorrow, get specific instructions from your client.
Your Lordship, tomorrow I have got some inconvenience. I've got multiple matters.
Every time you have some inconvenience.
What to
When do you
do, your
want?
Lordship?
When do you want?
Your Lordship has done from 7th to 16th, entire
When
days
do
I
you
came.
want, Mr.
I
Counsel?
came. I came
When do you
without telling
want,
anything.
When do you want?
Oh, just a minute, your Lordship. Third, my lords.
Yes, this is matter on third. By the time land council.
Oblige, your Lordship.
Mothers will get specific instructions with regard to the unsupervised visitation. Yes.
Number 8. Raghunath, Gautam Raghunath for petitioner.
Plus in this, yes, we did not meet after that to discuss anything further apart from whatever is agreed. Now, what it stands as of now is the 1 crore that he has agreed to pay. But I would like to submit that the respondent has not deviated or changed any of the terms. In fact, it is the petitioner who has been fluctuating from the beginning of the,
No, what is that why is it adjourned to today?
well, it's, what happened last time was all this while it was a chamber reconciliation. He had agreed to pay 1 crore. First, it was at the one shot. And then after your lordship intervened with the parties, he agreed that within 6 months, first your lordship suggested 3 months, but he agreed within 6 months that 50 lakhs would be cleared. Now 50 lakhs and after 6 months, 50 lakhs. Now regards the 35,000 which he had agreed earlier, now he went back on that. Now what he is telling is he'll bear all the expenses but will not pay 35,000. I even suggested that let an account be created for this 35,000 which he is paying right now. He's as of now paying 35,000 to the child. Let an account be created, let him not give it to her at all, put it to her account and let the amount be there. Let them have the cards, use it for the child. At the end of the year, whatever is remaining, an FD can be created in the name of the child, which can be used for his further educational expenses and all of that. After great efforts and after many months, we even at the instance of this court agreed that 35,000, if he is ready to bear all the other expenses, 20,000 will be paid by him, 15,000 she is ready to pay. Now that also is not agreed. In the guise of the settlement talks, the father has been exercising overnight visitation rights. But however, my lords, till now, the child is going to be 11 years. The father never had overnight visitation order from any of the court. The impugn order, even before your lordship, is that he has got 30% of the visitation from morning to evening. As of now, as per the joint memo that they had agreed earlier, school fees is paid by him. He pays 35,000 to her for the maintenance of the child. This is the arrangement. And he, once a week, Saturday, morning to evening, is his visitation time. Now, they should understand one thing, that because of this settlement and the efforts taken by the court or the councils and everything, because it has been going on from 1 year, the father definitely has been able to exercise his visitation rights. And mother has taken Herculean efforts to somehow convince, and whenever in fact the child wanted to come back, he puts it as if the mother is calling. It is not so. The child is of 11-year-old. Very soon he'll turn 11 years. He has a mind of his own. And before granting this 30%, the child was called to the court before the fourth additional family court. And the child explicitly refused to stay overnight. And that is the reason 30% was granted. And your lordship also, while presiding in the Dharwad bench, in fact, this was supposed to have been disposed of on that day, because your lordship did say that the same thing will be affirmed here. And then they started the settlement talks again. The father has been fluctuating on and off. So I do not know the stand of the father as of now, apart from this 1 crore of, I do not know in what time frame he is ready to pay and whether he is ready for this 20,000 per month. This is all that is there for discussion in this matter.
Now, in case if all this is not working out, what is the stand of your client?
Plus 30% is as it is granted by the family court. Now there is, because of the recent, I would say 2023, there was an incident that happened, and for that, a modification application was filed in WP 18604, where joint memo was made absolute. Now that modification application is still pending. It has not been adjudicated and disposed of. That is one thing. Second thing, if this settlement is called off and not happening, let the family court order be affirmed as your lordship had expressed. And let him take from morning to evening every day. We have no issues. And slowly, if he builds a relationship, probably he can file an application again, and that would not be a problem at all. And that is the reason I think there are two writ petitions because of this. They have also filed and we have filed against that. But however, I will fairly submit that let that 30% be affirmed by this court. I have no issues.
I'm extremely shocked, surprised, amazed by this last 10 minutes of complete concoction of whatever's transpired. Whatever was agreed upon, we were still holding on that this we would want to complete. And the fact that this Honorable Court has put so much of effort, that is the very purpose that we had even traveled there to state that we don't want that to be disturbed in any manner. This is not to try to utilize this, and as they're trying to make it out to be. In fact, it's quite the contrary, as you had mentioned. We are at a position today where we have absolutely nothing to lose, as I mentioned, Your Lordship. Contempts are pending against her, continuous contempts, and each time it's a warning that the next time she would not, criminal cases pending as against her. And Your Lordships have seen both parties in detail. This demand for this monthly also has come subsequently, not as they claim that we had agreed upon. It was never agreed upon, even by the previous bench. Your Lordship, we are still stating that we will comply with whatever directions Your Lordship states. Even now, if Your Lordship states that we have to close the matter, we will close. Absolutely no conditions, Your Lordship. All we are stating that if we have to argue the matter, we will continue to argue. But trying to state that Your Lordship had observed that we will hold this order only and all of that, Your Lordship, that was on whether we would comply going ahead with the agreement or not. So they cannot try to put words into this court's mouth. That's unfair. It's not correct. We will continue to argue this application, whether this order should be sustained or not. And since Your Lordship had already granted so many overnights, and Your Lordship has seen that it has gone off very well, whether that has to continue or not is the issue. Are we willing to abide by the terms and conditions as discussed? We are willing to. But to try to say we were paying anyway a monthly, the monthly is an interim. Now we are coming to a final settlement. We are paying the son's entire fees. We are willing to take care of all his expenses, plus give her 1 crore, despite her earning more than I do. Yet they want a monthly maintenance as an interim order continue, which I find quite absurd and ridiculous to expect. Family court has granted this matters complete. Family court has granted her 25 lakhs alimony. That matter is stayed already. She's not entitled to it. If we argue that matter and argue that she's not entitled to the 25, that will be going. If it is confirmed, all she gets is 25 lakhs. She's not even entitled to that half. She would have to pay the school fees, which I'm now saying I will pay. I'm taking care of all the expenses, which has not been ordered by the court. She changed the school voluntarily. She forgets all of this. She forgets all her admissions she's made in the cross-examination, as a result of which they came scurrying for a settlement. And now they trying to portray it as if we are trying to protract. No, Your Lordship might put me to terms, any terms I'm willing to abide by. This is quite ridiculous to try to make these kind of statements after last occasion in the chambers. They were supposed to see whether they want to continue with this demand of this monthly or not, or leave it, accept the 1 crore, entire amount we are going to pay in school fees, take care of all his expenses, every single, what more could one want? If I'm supposed to continue to take care of her expenses when she earns more than I do, is something we are not able to understand. She's not able to take care, we'll take care of the child. She can hand over custody, Your Lordship. But to now say that I must be punished if I'm not going to settle and pay her that amount of monthly maintenance, and I must be punished by revoking that overnight, which went off very well all along, only because I'm not willing to come to terms of her arm twisting, which I'm not agreeable now. Every single time the child is used as a tool. Your Lordship, if she says that there's a POXO case against him, he's misbehaving with the child, but if you pay me, I will give the child to you. Just doesn't make sense, Your Lordship. He's gone through hell with her, the number of cases, the number of humiliation that he's undergone. Yet he's willing to come and try to settle, and then they come up with this today. Instead of saying, let's come to a settlement and close it. Your Lordship, the amount of time, post-court hours spent on this, and now today they come and say this. Your Lordship, 1 crore will be paid. I'm undertaking that I'm going to take care of all his expenses. And I'm undertaking that all his school fees till he finishes his education, I will pay. Plus, I'm donating 1 crore for no reason. What more could one be expected to do? I am yet to understand, Your Lordship. And therefore, all I request is if they're willing to accept that, all right. Otherwise, we will argue it right away, Your Lordship.
But even as I speak, I'm sorry, of the settlement, what is going on. Just last week, she received a number of calls from the police and she had to go and take a bail in the court.
We have withheld that case. It
The
is not
father
proceeding.
has filed against her and the school for change of school, which she had got after filing an application in the court, filing of objections by them, arguing. The court passed an order directing the father to give the consent, which did not happen.
Criminal case in that.
Yes, he is filed and she had to take a bail just last week.
She messaged him, and I believe he's messaged her saying, we are holding it off, we are not proceeding.
That is not the
Ah,
case.
then what?
No, wait.
She has messaged him, and he's messaged her back.
School case.
Why would the police trouble her? And come to her house and say,
Nothing
"I
is
would arrest."
pressed. They have not pressed, and
I
he
can
has
keep the police
messaged her
here.
back.
I can keep the police here present.
Please keep them. Please keep them present.
I think the truth will come out.
Yes.
All along, we have not deviated from the settlement talks at all. Whatever your lordship, even now, my lords, we are ready. Whatever he has agreed, we are okay with that. He had agreed for 1 crore at one shot. And in fact, my lords, the first overnight, I have to recall and I have to remind the AOR the call that he had made and what he had said, but I do not want to submit that in the open court. It is not right on my part. I think the court knows what efforts the council has taken. Beyond this, in spite of she having to take the bail, I did tell her, if the matter steers to a settlement, we are always ready for it because there is dozen and more litigations between the parties, and more important than anything, I don't want the child to suffer. I want him to have happy moments with both the parents. He should have a happy childhood, I think.
No, the complete custody of the child is with the mother,
Correct, ma'am.
even by this compromise.
Yes,
And everybody is going to, all of you are going to withdraw all the cases.
yes.
No, the father will spend the entire school fees, extracurricular and other activities. And he undertakes, as per the compromise, he'll take care of everything.
Okay.
So there should be some contribution from the mother.
Plus, absolutely know this thing. The only difficulty she faces was, as was earlier also she faced during her matrimonial life. Now, if something the child has to enroll, the child can be called and asked, my lords, minus all the parties and the councils. What happens is, suppose he has to buy, say, a football, my lords, which is costing, say, 5,000. Now, the father will ask 10 questions. Why this football? Why not that? Why here? This store, that store? 10 questions. The child becomes frustrated at that. It's the same difficulty that the mother also faces.
Your Lordship, there
That is
can't
the-
be a
May I-
frustration. I'm
just
sorry.
submitting.
Just
One
one
minute,
second.
just one
Last
minute.
week
Let me
itself,
complete.
just 1 second. On this expenses only, last month, 60,000 rupees on a spectacles without asking any questions. Your Lordship, why will he say no to a football? And if I'm undertaking that I'm going to bear all the expenses, it would be a violation of my undertaking. If he wants spectacles for 60,000 rupees and he still gives it to him without any questions, why would he say no to a football? Your Lordship, this is all, if I'm going to undertake, they can even make a list stating that I will undertake to all these expenses anytime he wants. I will sign that also, Your Lordship. These are all excuses to come out of the settlement so that I don't get overnight custody. They are upset that this overnight custody has gone on peacefully for so long. They don't know how to overcome that. And therefore, some unrealistic demands just to scuttle the settlement process. That is all there is now. Child didn't come this Sunday stating Kannada exam. We are not complaining, Your Lordship. He said, I will teach Kannada, come. He said, no, he's not willing to. We left it. We don't want any unnecessarily. If this is the way it has to go about, we will accept. There are times when she will not send, it is okay. We don't want to even make that into a contempt. We are not. But we have come about to this far. Why unnecessarily keep coming up with extra demands to try to scuttle the process so that the overnight is revoked? This is what I have understood from this whole thing.
Because where was overnight given to revoke? And why is the mother not appreciated even once for the efforts that she takes? The child does not go, the mother is blamed. The child goes, the mother is not appreciated. That is a really sad thing. And what the father has agreed, why is he going back on that? I mean, which party will appreciate if she has to go take a bail, my lords, during settlement talks? Plus, I am at the hands of your lordship. I bow to your lordship, whatever the court feels that the mother has to, because right now he is continuing to pay 35,000. I don't see any reason. What is the problem in depositing some amount? Even then, even that I have.
The small distinction which your client is not able to understand is that is pending proceedings. Now the entire
Yes.
proceedings are going to come to an end.
Yes, that's right.
Come to an end. And
That is the
earlier,
reason
both
I
of them
suggested.
earlier, like half of the fees, that issue of changing the school and all,
Yes,
it is
it was by
always
court,
live between
yes.
them. No, leaving that also apart. Now, they say whatever condition you impose with regard to spending of taking care of the expenditure of the child, they are ready. Maybe after everything, after giving divorce to, I mean, after settling everything, maybe he feels that what he is giving is not to his son, but for her. That may be.
No,
his-
that is why I said, let him
They
create an
use
account in the
it.
name of the child. Let him not, now he is giving it to her. Don't
No,
want.
who will use it if it is in the name of the child also?
Let him use it, my lord. That's what I'm saying.
Use it.
I'm sorry, my lord.
Both can use it.
No, that is the reason I said, let an account be created in the name of the child. Let him put 35,000. That is just an interim maintenance.
And one more
Probably the
thing is,
court.
one more thing is, as you
Yes.
know,
Huh.
the child is very smart. And any request from him, from his side, if the father is not complying or he is not doing anything, you know what would be the consequences. I don't think.
No, so
you
what he
take that
does is,
risk.
as of now, what he does is, he comes running to her and says, I do not want to get into a fight with him. You buy me this. That should not become the norm. That is all, is her fear. That's all, nothing else. Because even she does not want to fight with him. She does not want to get into a verbal
It
discussion with him.
hardly takes 5 minutes for the court to pass order on the merits of it.
That's right, my lord.
Ultimately, both your clients would be.
Again, they would
be
go
the-
back and litigate for a number of years.
Never, it
Correct.
would never, this litigation.
Very
would
true. We
never
have come
end.
this far.
They can
yes.
never be with this peace of mind, and unnecessarily you will, somebody, compromise is that. Compromise is not what will happen on your terms.
Plus, at least the 1 crore which he had agreed to give at one shot, even that is not happening. He's taking 1 year. By now, that 1 crore would have been over, my lords, if he had agreed in Jan
So,
2024.
is it that if he is ready to complete that 1 crore, then this demand of additional money would go from your client if it is made
At one go,
immediately?
my lords?
Ah.
Can I just
Ask.
ask? Plus, yes, she's okay, provided everything is in writing about the expenses that he should not go back. She still says, yes, I'll abide by that.
Talk to your client again.
The same day, Monday, 3rd, can this be
Some other, the other matter is coming
Yes.
on 3rd.
3rd?
We'll
Yes.
have it on 3rd. Better, I think you should come down to that.
Not at 1 year or whatever.
Mm.
Can be reduced marginally and brought down to something that I just don't know. One shot, I think he does not have now. If he had, he would have closed one.
Or else,
50
like,
like that,
something like 3 months.
Please, I should put for.
This is matter on 3rd February.
Your lordship, the weekend visitation also, as earlier.
The
Oh, she'll
visit,
say, I think
the
by exam
weekend
it will be over
visitation, as per the earlier arrangement, shall go on.
Please, obliged.
Grateful. my lord.
9 for dismissal. Vignesh. J. Shankaragowda, for petitioner. Venkatesh.
To the file. Or else pass over, we'll see in the afternoon. They don't turn up, then we'll dismiss it.
That's serial number 9, 10, serial number 10. P. Shivakumar, Gopal Krishnamurthy C.
Respondent.
Statement was filed along with the IA. The petitioner entered appearance before the trial court on 10/6/2016. IA was, he filed an IA on 17/8/2016 for extension of time to file written statement. But that was rejected. Thereafter, he has filed IA number 4 on 23/11/2016 along with the written statement.
IA number 4 on?
4 under section 151 of CH.
On?
Written statement to take the.
When was that?
23/11/2016. That IA was rejected on 10/4/2014.
Come to the impugned order.
Impugned order looks at page, right copy is at page number 27. The right copy, 10/4/2017.
27. Yes.
The plaintiff present advocate for defendant filed IA number 4 under section 151 of CPC to take the written statement on record. This defendant came on record on 1/6/2016 and the sufficient opportunity has been provided, but the defendant failed to file the written statement. And on 23/11 is come up with the IA number 4. The whole trial court has indicated that after 120 days, the written statement shall not be taken on record. Here 90 days is the time as per the CPC. Once it was amended, this Karnataka Amendment Act is not in it. And after 90 days, the court's discretion can be invoked. That is why the application is filed under 151. Suit is for specific performance. Agreement is of the year 1994. We have denied in the written statement that the.
What do you say?
Lords, petition may be allowed, my lords, we have no objections on
Please come.
on the condition of certain imposing of
Uh-huh.
cost. On cost, it may be allowed.
The agreed with the order dated 10/4/2017, whereby the court had rejected the IA 4, which is filed in section 151 CPC, to take the written statement on record. The defendant is before this court. The respondent herein has filed a suit for suit seeking specific performance of an agreement of sale dated 9/11/1994. In that, the defendant had entered appearance on 1/6/2016 and had filed an application on 17/8/2016 seeking extension of time. And thereafter came up with IA number 4 to take the written statement on record. The court had dismissed that application, that the right to file the written statement is forfeited after 120 days and rejected the IA. Next parallel and counsel appearing for the petitioner submits that the court has the discretion to allow to grant the leave to file the written statement even after 90 days. And the finding of the court that the right is forfeited is contrary to law. It is submitted that the suit is for specific performance of an agreement of sale dated 1994, of the year 1994, unless an opportunity is given to contest the suit. The defendant would be put to irreparable loss and hardship. All these aspects were not considered by the court. Shall I record that,
Please, my lords. On cost, it may be made.
Then counsel submits that, for the plaintiff submits that, in spite of giving an opportunity, the defendants are not, the defendants who have entered appearance on 10/6/2016. They have failed to file the written statement till 23/11/2016. Court had rightly considered the same and rejected the application. That's IA number 4. Next, having heard the counsels on either side, there is a material on record. They have entered appearance on 10/6/2016 They have not, the present IA is filed on 23/11/2016. The observation of the court that the right itself is forfeited cannot be appreciated. The court has got the discretion to grant leave to the defendant to file the written statement, considering the fact that this is suit for specific performance based on an agreement of sale of the year 1994. And unless the opportunity is given, it would cause a lot of hardship to the defendant. This court deems it appropriate to allow this application on cause. Accordingly, the court is passing the following order. The IA number so and so. Oh, the order impugned is set aside. IA number filed by the defendant is allowed on the condition that he shall pay an amount of rupees 2,000 to the plaintiff. Accordingly, allowed.
Cell number 11, Abhinav R for petitioner.
Yes. Yes.
Rejected or for depositing 50% of the rent, but if you want for partition, relating to the estate of the deceased wife, the suit is between the husband and the mother-in-law, the wife's mother, approximately the petitioner's wife after due to cancer. Properties are available for partition. Now the defendant respondent before my lord is deriving the entire rent. Suit is one for partition 50%. So we requested the court that amount can be deposited in the court or in a fixed deposit. Subject to the outcome of the litigation, it can be released to the party.
How much is share he is seeking?
50%.
50.
Yes,
So 50% of the proceeds shall be deposited.
yes. I just report on the deposit.
Let's see the order.
Next, my lord. What they would say is, my lord, the tenants are not made parties. Tenants need not be made as parties. That is the first ground. Next, my lord, we can say. That my lord will get the operating portion from my lord page number 42 onward. That is the first aspect. Second aspect is they say in the final relief I have not sought for deposit of rent. But in the suit for partition, they only ask for partition. Question of asking for deposit of rents in the main relief will not arise. Partition and separate possession is what I can ask for. So these are the two grounds on which not the application.
Let's read from para number 9.
Defendant has filed objections denied that the assertion of aid in properties are jointly owned for this period. According to the defendant, the absolute owner of the aid in property denied the execution of the gift deed by her daughter in favor of the plaintiff. Therefore, the defendant would reject the application. On the result of the record, the plaintiff contended that the wife, who is the father of the defendant, has executed a registered gift deed in 4/7/2013 in his favor and gifted her share in the future property in favor of the plaintiff, and hence he is entitled for half share in the future property. In case of the defendant that her daughter has no right over the aid in future property, and hence she has no right to execute the gift deed. On the result of the record, plaintiff contended that aid in scheduled properties.
No, let us understand this. What are these A and B scheduled properties?
Sir, there are two properties, A and B property, crucial property. Lord, that belong to my father-in-law, that is my wife's father. Lord, there was a dispute between the mother and father. And in that settlement, Lord, two properties were given to the daughter and to the mother, wife.
How?
By a court decree.
By compromise decree.
Yes, by compromise decree before the court, that I have also produced. So 50% was given to the daughter, 50% was given to the wife. Daughter is the person whom I married. Unfortunately, she passed away due to cancer. Before she passed away, in relation to her 50%, she executed a registered gift deed in my favor in the year 2013. She passed away in the year 2015, 2 years prior to that. Neither
So 50% of the property is already in your name.
Yes, in my name by means of a gift deed. The contention is she had no right to execute the gift deed. That is the contention which they have raised and which the court has recorded. Para 11, not particulars of the tenants are not made out. On particular para 12.
Please come. The agreed by the orders passed on I number 3. The plaintiff is before this court. The plaintiff is the son-in-law and the defendant is the mother-in-law. The plaintiff had sought partition of the suit scheduled property where by virtue of a judgment and decree, 50% of the properties were allotted to the plaintiff's wife. A and B properties were allotted to the plaintiff's wife, and 50% of the properties were allotted to the defendant, who is none other than the mother-in-law. It is a case of the defendant that the wife of the plaintiff has no right to execute a gift deed in favor of the plaintiff. The present IA came to be filed, directing the defendants to pay 50% of the monthly rent pertaining to the A and B scheduled properties to the plaintiff, or to deposit the same in the court or in nationalized bank. That came to be dismissed by order impugned. That on perusal of the relief sought in the plaint, no such relief is claimed to award the rent or mean profits, and no court fee is paid to the effect of claiming rent. Generally, you seek for mean profits also in a suit for partition. Mhm.
Or in case it's a joint family property, a lot of accounts are to be maintained.
But now these properties also in her share, in her possession.
But he is receiving the rent.
Hmm.
Therefore, my lord, rent can be deposited to the extent that
No, you have to sort for it, you have to seek for the mean profits.
these profits is there are agricultural land where my lord, there will be my lord, crop or that.
The plaintiff is reducing evidence from the date of framing. Anyhow, if you are entitled for something, then the court fees and all, if any have to be paid, court will recover that.
Time of trial.
The plaintiff, instead of reducing evidence from the date of framing of issue, file the present application. And a counterclaim is made. The gift deed dated 4/7/2013 is to declare it as null and void, and also to declare the will dated 23/7/2015 as null and void. The court observes that the title of the wife of the plaintiff to execute the gift deed is also in serious dispute. As it is stated that as no relief is claimed to the plaintiff, and also in the absence of tenants as parties, the plaintiff is not entitled for any relief. The land counsel appearing for the plaintiff submits that when, as per the judgment and decree, 50% of the NB scheduled properties are given to his wife, and the mother-in-law is enjoying the properties. The court ought to have granted the relief as sought. They submitted that the court had observed that the tenants has to be made parties, which is not necessary. And as the mother-in-law is receiving the rents, and as she is as she is a party, making the tenants as a party as parties to this application is not necessary. Next para, no, though notice is served on the respondents. No. This court by order dated 27/2/2024. Why substituted service you have taken?
No, but, sir.
Is held sufficient.
The served, my lord, they are not turned up before this court, and therefore, my lord, it is held.
No, it might not be that.
They are refused to take the notice. Therefore-
Maybe that,
Ah, yes,
maybe that
yes. They are refused to take the notice.
is not claimed
Yes, sir.
as though notice to the respondent is returned as not claimed. The court by order dated 27/2/2024 has held that and held that the notice to the respondent sufficient. Next part, having heard the counsel for the petition, there is a material on record. The first contains differs the observation of the court with regard to the court fees. If the petitioner, if the plaintiff is entitled for any mean profits, and any amount is awarded by the court, and if any court fees has to be paid, the court can always direct the plaintiff to pay the court fees. In the facts and circumstances, where basing on a judgment and decree passed by a civil and passed with the family court, where 50% of the properties of A and B schedule are allotted to the daughter and which are given by way of a gift deed to the husband. Though the defendant mother-in-law denies the same, which has to be eventually decided by the court, as the mother-in-law alone is enjoying the rents. Rents in that rents, the court ought to have passed an order directing the mother-in-law to deposit the rents in the court. In that view of the matter, this court is passing the following order: IA number so and so, the order or impugned date so and so is set aside, and the defendant shall deposit the rents in respect to what are they, A and B scheduled properties in the suit account. Which is subject to the.
One submission.
My lords, may I seek the
Serial
indulgence
number.
of this honorable court, my lords? My lords, serial number 18. My lords, last time this honorable court had given me time, my lords,
Yes.
regarding compliance of that particular filing of an amended cost title. My lords, I went to the office, but the file was sent to a wrong court. That is court hall number 11, it was sent. And after I made a submission there, it was posted before this 1 week
Actually,
time.
it would have been dismissed.
My lords, I'm sorry. I
thought we'll give an opportunity. That's why it is passed over.
Yes, sorry to say, my lords, I was an advocate
and finally a week's time is granted.
much obliged, my lords, much obliged.
Serial number 30, will I appear for respondents. I seek for adjournment. I inform the petitioner.
Like specifically, I think everybody can read the cost list. No mentioning at 1:30. One has to mention it 10:30. Here is the case where the case is for dismissal. He has mentioned court entertain. That means that no, that doesn't mean that in every case the court will entertain.
Serial number 18. 18 delete from caption illa. 1 week finally. Comply, yeah. Filing stands for empty order. Delete from caption.
ಅದು ಆರ್ಡರ್ 1 week.
Sir.
The list. And submission. Passport, how many passports? The judgment I'll dictate. End of the list. What is the password?
Password is 9.
Huh?
In serial number 30, my limited wants some accommodation. I'm for the petitioner. And you also slightly pointed out to me on 23rd, last Friday, Thursday, that I need for some sort of matter today. But for the, including for the other side, it's speaking time.
Why?
Senior is not keeping well. Your Lordship. It may be listed on 12th or 13th.
You have a stay in your favor? You have a stay in your favor?
Yes.
This is matter on April 22nd at the request of non-cons to the respondent. Yes. Interim order earlier granted is extended till then. Yes, next.
Serial number 9, password 14.
That is in respect of your wife and your wife to others after the decree. No, that they have filed the claim petition.
Children have filed a suit for partition and they have offended their
No. Order 21 rule 97 who filed?
Applied with the object,
Who are the objectors?
they are the purchasers of only my children.
So from wife to children, children to them. Yes.
That is over, there I have not.
No, as of now, you are not the owner of the property. You have no issue with regard to why the contract has to be resigned.
I think first petitioner will say it, there was second petitioner, before filing of the suit, that same deed has been not questioned by the
Yes, call the list.
Serial number 9. Password serial number 9.
Why is it passed over?
Because nobody.
Oh, no representation on behalf of, as there is no representation, look at the date on so and so the matter is directed to be listed today and the caption for dismissal. Today in the forenoon as well as in the afternoon, there is no representation accordingly. Dismiss for non-prosecution. Yes, next.
Serial number 12. Serial number 12. MS Nagaraj.
Who appears for the respondent
That is served on the petition.
on behalf of opposes matter for dismissal on 29 votes?
Deputy Jagadish.
H.D. Jagdish is the advocate appearing. Heard the learn cons for the petitioner, no representation for the respondent. This is matter as partner tomorrow. Yes, next.
Serial number
Tomorrow.
13.
Yes,
Serial number 13.
13 is adjourned now. What is that number? 30. Yes.
Serial number 13. C. Vijay Kumar.
Huh?
That's fine. To take. steps
You want to appear as a party in person? Huh?
14%.
No, for petitioner, yes, my concern is, kind of understand.
They have to take
But-
steps for this is that they require some time to take steps. Please submit.
For taking steps in respect of deceased Arthi. Finally, 2 weeks' time is granted, or else the petition shall stand dismissed in respect of respondent number 3.
For orders, serial number.
This is in dismissal
No, for orders.
before 13.
13 is.
Delete from the caption dismissal.
Yes.
Yes,
Serial number 14.
yes.
14 for orders. Available.
Non-filing of IA for substituted service in respect of proposed R1. When the petitioner died, 2015 writ petition. Hmm? Then we'll allow that application. Look at it, is it put up?
That application to bring the last petitioner is telling me, please no.
Let that be put up. It is submitted that the petitioner died and the petition is filed to bring the LRs on record. Registry is directed to place the same on record. List is marked tomorrow, this 15.
Serial number 15. Sadashivaya KG, petitioner. Yes, Bal Gangadhar for R1. Memo for retirement filed by.
No representation. This is marked tomorrow for dismissal.
Serial number 16.
FA respondent.
You filed a memo to that effect? Yes.
Yes. The application for substituted service is filed. Officers raised the point notice is not. But however, they have filed a petition.
Where is the order of this court? Why it is not served on the last occasion? Insufficient address. The application is filed in substitute service of notice on respondent.
So many respondents are there. There in different editions, they are seeking paper publication in Bangalore, Mysore, Bellary, Dharwad and Belgaum.
You can make a separate application. Why are you making it so complicated?
Edition is different.
Huh?
Edition is different.
Where is that? The present application is filed seeking the substitute service of notice on respondents number 8 to 21, 23, 24, 26 to 34, 37 to 39, 41, 42, 43 and 46. By way of paper publication in Udayavani, Bangalore edition. In respect of respondents number 8, 9, 10, 11, 12, 14, 15, 16, 19, 20, 21, 23, 24, 26, 27, 28, 29, 30, 31, 34, 37 to 39, 41, 42 and 46 in Udayavani, Mandya edition. And in respect of respondent number 13 in Udayavani, Mysore edition, comma, for respondents 13 and 17 and 32, Udayavani, Bellary edition. In respect of respondent number 18, Udayavani, Dharwad edition. And for respondent number 43, Udayavani, Belgaum edition. And Udayam Mandya edition for respondent number 13. What did I say? No. Udayavani, Mandya, huh? 13. Mysore edition for respondent number 17 and 32. Bellary edition for respondent number 18. Dharwad edition for respondent number 43. And Belgaum edition for respondent number 33. No, 33. Accordingly, the application, the IA is ordered and petition is permitted to take out notice as ordered by the court in respect of the as ordered by the as stated in the application on or before mentioning the date of hearing as so. And where is the other memo? Where is the other one? It is stated that
Memo.
that advocate for the respondent has stated that the first respondent died. Respondent number 3 died. Now a memo is filed stating that Respondent number 3 died on 23/10/2021, and the legal representatives of the representatives of the respondent number 3 are already on record, that is petitioner and respondent number 1, 2, and 4. Accordingly, the memo is taken, and to that effect, the amendment shall be carried out in the cost item. Interim order earlier granted is extended till the next date of meeting. Yes.
Cell number 17. Again, Narayan Sharma for petitioner.
First, no, respond in respect, the service of notice in respect to R4, R17, R18 is returned as refuse, amounts to deemed service of notice. Then coming to unserved covered return with postal shara in respect of 12 as unclaimed, notice to respondent number 12 returned as unclaimed on the amounts to deemed service of notice. Then what about non-furnishing R7C, R11? What did you do? It is submitted that in respect of R7C, R11 and R2, the steps are already taken, post after service of notice. Interim order earlier granted is extended till that. Yes, next.
Cell number 18. 18 urgent. Cell number 19. Hanuman
That's why a memo to be filed. Then dispensation of notice on R4. For that, you have to file a memo. That's why last occasion when it came, I said you filed separate memos for that. That's why it is indicating. That's why it is adjourned. Please file separate memos. Next, this is matter. Next week on 3rd of February. Yes, next.
Hearing on interlocutory application, cell number 20. Prabhu Gaud B. Tumbigi for petitioner.
No representation. On behalf of both the parties, this is matter on 15th of April. Don't extend interim order.
Cell number 21.
For the respondent, Your Honor.
Chandrasekhar, D.K. Chandrasekhar.
Interim order is there.
No minutes.
No representation for the petitioner. This is matter on 8th of April. Councillor, the respondent is present. Yes, 22.
Cell number 22. H.N. Basavaraju.
Respondent. Who is for the petitioner?
It's H.N. Basavaraju for petitioner.
Memo for? What is memo for disposal?
Memo for disposal.
Take that.
Last occasion. Last occasion, she gave the memo for disposal. Some clarification is that.
Then calls for the petitioner submits that the petition may be dismissed as not pressed. As the suit itself is going to be disposed of. Accordingly, memo is taken on record. And the petition is dismissed as not pressed. Yes, next. Next. Continue the list.
Cell for admission, cell number 23.
Serial number 23, my lord,
I
is
appear for the
requesting a passover on application that they have filed.
But is an application has been filed by the petitioner seeking for a transfer of the matter from the honorable, this honorable court to the
NCLT for why this is, I think, 3 times adjournment.
Yes, I
is
have
filed.
filed my objections. I have filed my objection statement, my lord. It was filed in the counter yesterday afternoon. I hope it is brought on.
Hmm.
The objection is we have not taken any steps because the circular came in 2016, so that doesn't come at all. This honorable court is here, even the Supreme Court is clear, it's a discretionary order. Can be transferred. Why we we want to go before the NCLT, it's, if insolvency resolution professional is appointed, then there can be a settlement, because these people are not coming forward for anything.
There is a senior counsel engagement in this matter, my lord. I'm requesting for a passover and not an adjournment.
3:15,
I
what
am-
passover you want?
I understand he's on his legs in another court hall.
Let him come. Yes. Or else you want it tomorrow? Hmm? No, if you want, the court will take up for you.
Again, you should not come,
No.
it's a senior counsel.
I do not have, that is not an excuse, my lords. I bow down before your lordship, but his legs at the
No,
moment. That is
This
either
court
today
is asking
passover
whether
or
it's-
tomorrow. I
Tomorrow. At the request of learned counsel, the respondent.
Preliminary hearing B group, CL number 24. CL number 24, Chandranath Tariga K for petitioner. Ravi Shankar.
Is it correct?
Madam. Last date of hearing also they
For
made us.
settlement. Parties are, the compromise talks are going on. This is matter on 25th or 12th of March. Yes.
CL number 25. CL number 25. Anant Krishnamurthy. C.T. Parmeshwarappa for respondent.
This case I am open for the government. Respond number 40. That copy is not shown to them. State board, state.
This, Gautam Raghunath, can't happen today, or this side of the week it was. It is some other. Tell them. Yes.
I'm appearing for the state in this case, not the copy is not served that state. Next.
Serve them. This is matter on 11th of March.
CL
Yes.
number 28, 26.
At the request of, we submitted that the papers are not served on the state.
CL number 26. S.V. Bhatt. Huh? He's lying.
Where will he? This is matter tomorrow. Tell him that it is posted to tomorrow.
CL number 27. Usha M.V. for petitioner. H.S. Prashant.
No representation. This is matter on 28th of April.
CL number
Don't,
20.
in all these matters where there is no representation, don't extend in someone. Yes.
CL number 28.
Lord,
Sadashivaya KG.
I appear
for respondent in this case. In another matter, I appear for petitioner.
Yes.
Three to 6 and 12
Yes.
and 8 to 10.
Ready?
I'm ready because
Yes. First matter, who appears for the petitioner?
Mr.
Sadashivaya.
Sadashivaya is not there.
No representation for the petitioner. And who appears in 28.1 for the petitioner?
I appear, my lord. I appear.
No representation for the petitioner in WP 30403 of 2018. Petitioner, counsel for the petitioner and respondent in WP number. Petitioner in 39514 of 2018 is present. To have an interim order in your favor,
Yes, my lord.
the list is matters on 25th March. Extend interim order in 28.1. Yes,
Date is given.
25th March.
yes.
CL number 29. Sagar BB.
We'll give them an opportunity. We'll give them an opportunity.
Yes.
No representation for the respondent, counsel for the petition is present. This matter is part heard on 4th of February. Intermode alia granted is extended till then.
Please.
Cell number 30 adjourned, 31. Madhukar M. Deshpande.
Petitioner. Respondent number 8 and 10, 8 to 10.
Huh?
Respondent number 8 to 10.
Who appears for the other respondents? Mr.
Vivek
Vivek
Kolla.
Kolla for R1.
Vekulla for R1.
You have a stay in your favor? Also, the petition is present, no representation for the respondents except for respondent number 8.
8 and 10. 10 to 10.
8 and 10. Let's this matter on 19th of March. Intermode alia granted is extended till then.
Cell number 32. Kumar Ram CM for petitioner.
I go for respondent 1 and 2 in this case.
Mediation.
I filed a memo regarding the reporting the death of respondent 1 and 2.
Respondent number?
1 and 2.
I had a scheme a lot. So the trial court also, the matter not proceeding, they are passing in the year 2020. The suit is updated in the trial court also as well as your matter. If they bring the LRs and record in the trial court, I will give liberty to reopen this matter. No,
As of now, I have not got any instructions from my client. I will just, but if any LS details are there, I will just hand it over. All the details will be handed to me.
They come in the record, if they come in record in trial court, I'll be able to bring them here. That is a constraint.
This is a writ petition of 2019, when the respondent died.
In the year 2020.
Have you taken any steps before the trial court?
No, in fact, Your Honor, I came to know in the last year in the month of August.
You came to know in the month of August last year.
And afterwards I filed a memo. After then,
Did you file the memo?
I have filed it on 13/8/2024. So after then, there is no instruction from their LRs or what. So henceforth, I may be given a chance so that I will give the details of the LRs.
List is matter. It is submitted to the sole respondent died. And you'll get specific instruction. This is matter on 5th of March.
Cell number 33.
5th of March.
If the trial court is intends to close the suit that no steps have been taken and the suit abated, then this will.
Why should we tell the court? The court knows what to do.
They will stay on. It's only the matter did not reach from 14/8/24 states have not been extended. Subsequently, the court will note that the LR passed not been brought on the sorry. The contesting respondents are passed away. So now the trial court is not proceeding the matter because there was a stay all along. So let that.
Then I'll vacate this stay and ask the court. Otherwise, how to clarify? There is a stay before by this court.
Subsequently, there will be no extension of.
Shall I clarify that?
After 14/8/25, yes.
There is no though the earlier stay is granted by this court, it was not extended thereafter. And the trial court is at liberty to proceed with the matter. Yes.
Cell number 33. Sharvana S for petitioner.
Milords appear for the petitioner, Milords.
Yeah.
Milords appear for Milords in the last vacation. Lordship directed me to produce the order sheet because the Lordship wanted to know whether after filing the objector application I raised the maintainability. Milords, I couldn't get the order sheet. Milords, another 3-4 days accommodation. Milords.
This is matter on 5th of February at the request of counsel of the petitioner.
Intermodal may be kindly. Intermodal may be kindly.
Intermode alia granted is extended.
Great.
Cell number 34. A.M. Rajana Shetty for petitioner. K.S. Nagareddy. Respondent.
I am the respondent in 34.1, my lord.
What is this 34 and 34.1?
All the matters are same, Your Honor. Filed against the person for intention filed by the petitioner, Your Honor. They sought a they filed IA seeking the amendment of the claims, Your Honor. They sought the amendment of like the para 9 and the prayer, Your Honor.
3 different suits.
Yeah, in 3 different suits. In fact, there were 5 suits, Your Honor. They had filed the same application in the other suits. Trial court in 2 matters have allowed the application, in 3 matters has rejected the application. for amendment.
So now let's come to the first matter. That's 34. Now what is the order? Please come to the impugned order.
The reasons are starting at para 36, Your Honor.
Page number.
36, Your Honor, in page. Right, is only that the nature of the suit will be changed if the para is allowed, and the prayer we are seeking is similar to para B, and that's the reason the prayer has been rejected, Your Honor. In fact, we have filed annexure, Your Honor, in the same matter, the trial court is allowed.
Now, what is the amendment that we saw? That is at page number 37.
I have sought the amendment that taking it in the person in the property for more than 45 years and cannot be disputed from the.
Where are you reading?
33, sorry.
36, it is extracted. In the order.
The amendment you have sought is in page
7, para number 7. Proposed amendment. Page number 37, para number 7 of the impugned order.
Yes, Your Honor, this is the prayer that it's in main plain, Your Honor, B.
No, it's you are seeking the amendment is this.
Your Honor, what I'm seeking the amendment is in page 33 of the orders, Your Honor. I mean, the 33, page 33, page 2 of the order.
Please come to your affidavit. Your affidavit. What is the suit for?
Injunction, Your Honor.
And what is the purpose of this amendment?
Your Honor, India has it has acquired the land, but it has left off the land, which is not being.
That is your case in the main plaint itself. That's your case. So what is the big difference is going to make? For what purpose you want this amendment, which is already pleaded?
I mean, to be clear, that I've been in possession for last 45 years, I've just included in that para. In the prior question, I'm asking because it's not, the project has not been included, let the media, let them not.
Court has rightly observed it doesn't make any sense, the prayer that you sought.
Court has allowed other. Annexure H.
Annexure?
H, Your Honor. This is India 5 3.
Where is that?
Annexure H, page 57, Your Honor. 64 is the review, Your Honor. In fact, I find both the cases in both annexure H and both are by the same trial court in the connected cases. In fact, all the case was heard in all the 5 minutes and also posted on the case. But all the parts are on different days.
Same judge.
Same judge. Where it has been allowed, the filing court says that.
No, the next is also rejected at 39 and 40.
Pardon me,
40 is also rejected. Page number 40. Where are the orders where it is allowed?
No. That is starts from the 45 in the annexure G.
Let's see that.
The reading starts from the length of 52 is the page for the first order.
What do you say? How can there be a discrimination like this? These kind of orders?
One submission, madam. I am representing only in 34.1, my lord. Once I'll go through the other orders, if they have produced the IA and objections of the
Give
other
you the set of papers.
then only I can say if it is the same amendment or not.
But there can't be this kind of orders by the very same
Maybe,
judge.
my lord, I don't have any papers.
Show it to him, those orders. List is matter day after tomorrow. Then counsel appearing for the BDA submits that. Then counsel appearing for the petitioner submits that.
And
When 5
yes, ma'am.
applications are filed seeking amendment of plaint on similar grounds, 3 applications are allowed by the court and 2 are 3 are dismissed and 2 are allowed. Then counsel appearing for the respondent BDA submits that he is not aware of those orders which are allowed by the court. Then counsel for the petitioner plaintiff shall serve the said orders on the counsel appearing. for the
And also the IS, my lord.
IAS.
IA and
What is the proposed amendment they have to see from the IA affidavit and the impugned orders on the counsel appearing for the respondent list is marked on 4th February.
in 34.1, my lord. I am only appearing in 34.1.
Once everything is one and the same, in 34.1 give him.
Yes.
Yes.
There is no 35, Prabhu would be Tumgi for petitioner. Telecast judgment.
In this case, my lords. My lords, on the last date of hearing, my lords have directed us to furnish the family tree and other documents. I had undertaken that I have a Sagwali cheat in favor of my grandfather, Nane Naik. So that is,
So this is on. in the
please,
regard.
where that.
No representation for the petitioner, counsel for the respondent is present. This is marked tomorrow for dismissal.
My lords, can I request, my lords, there are certain taxpayer receipts which I have to collect it from the taluk office. Now some scanning work is been taking place.
This is marked
So
on 10th of March. at the
no,
request
my
of-
lords, after 5th of February, any date, my lords.
5th of February, any date is not possible. We'll list it on 5th of March. Fifth of March, at the request of Friend Counsel, the respondent, no representation for the petitioner. Yes.
Cell number
Much of
36, Gowda for petitioner, Harish HV for respondent.
This time also they did not appear before the court.
They did not appear.
They did not. The matter is simple, lordships.
The
Suit,
list is no representation for the petitioner. Heard the counsel for the respondent in part. List this matter tomorrow as part heard.
please. Lord.
Yes,
Cell
please,
number
sir.
37,
I appear for petitioner, my lord.
Yes.
Shekhar Shetty. HSC Shivram for R1.
Counsel for the petitioner appeared online. No representation for the respondents. Shall we take up this matter tomorrow?
Hmm.
Shall we
Pardon,
take
my
up-
lord.
shall I take up this matter tomorrow?
I appear for petitioner, my lord. I'm ready to work.
Respondent is not there.
One request I want to make before your lordship. It may be posted after 13-2 because it is decree set aside. Still is claiming all rights.
This is matter, no representation.
Virgil's decree is now
This is
in
matter
appeal.
on-
It is posted on 13-2.
5th of March.
Cell number
Very
30,
much.
38,
Yes.
Deepak Shetty for petitioner.
After R5, R6, not
Number
coming in
yes.
cross title. What is this?
Is not ordered in respect of R35 to party.
Please use the mic.
Numbering of that respondent, my lord. Oversightly, my lord, it is shown as a 5, thereafter 7. There's a serial number given to the respondent.
For some
Look at the cost rate.
of the respondent notice is not ordered.
You have not shown them at all as party or respondent. That's what.
Yeah, I have shown as a respondent, but
Look at the cost rate.
there is 5, my lord. Thereafter, it should be a 6, but it turned into 7. It is a typographical error. Which is, this respondent number 5, GS Siddharaju. Thereafter, 7. My lord, it is serial number mistake, my lord. And I mentioned the respondent number 6 there, my lord. It's only the serial number mistake.
So what is to be done?
I will correct it, my lord, now itself. Only the serial number was.
Give it to him. The petitioner is permitted to correct the number of the respondents as are read in the cost rate. Yes, listed tomorrow.
Not tomorrow, my lord, next week.
List this matter on 11th of March.
Cell number 39, Harish HV for petitioner, CR Abdul Rashid.
Sam, but
Correction.
petitioner, my lord, this is a suit for partition, lordship. In a suit for partition, at the time of defendant's evidence, I had taken an earlier partition in the written statement. I have taken the stand. And my lord, I had produced the document, but bona fide mistake I had not marked. After the evidence, the examination in chief, when the matter is posted for cross-examination, I filed an application to reopen and recall and for marking the document called Palupatti lodge. And the court, my lord, even in the.
When was the evidence closed?
My lord, my lord, that is immediately we have, even before the cross-examination commenced, we filed the application, lordships. That's the observation also. Only thing is that, my lord, whether this Palupatti,
Come to the.
I'll come to the order. Order is at the page, lordships, right at page 15, lordships. The defendant number 15, shall I, lordships? The defendant number 15 has filed this application seeking to reopen the evidence and produce one unregistered partition deed dated 21/10/97. The said application is filed at the stage of cross-examination of DW1, my cross-examination. my lord. Firstly, the application consists of two prayers: reopen defendant side evidence and produce documentary evidence. As the rule of law says, no person can pray two prayers in one application. Therefore, the present application deserves to be dismissed at the outset. Secondly, it is stated that defendant himself, the document produced by him is an unregistered partition deed dated 21/10/97. The plaintiff has filed a suit for partition and separate portion. When the case is set down for cross-examination of DW1, the defendant filed the above said application, which is styled as partition deed. On the background of the arguments canvassed by the counsel of the parties, the court has gone through the recitals of the document dated 21/10/97. On perusal of the document, the recital determined that the document is a partition deed, and as per 17 of the Indian Registration Act, it is mandatory that the partition deed must be registered. It is settled principle unregistered document cannot be received in evidence. The defendant urged that document shall be marked for collateral purpose. In Indian Registration Act, so and so was enacted with the object of.
Okay.
1 minute. No, on that. ಮೇಡಮ್ ಇದೇನಾಗಿದೆ ಇದು ತಹಸೀಲ್ದಾರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಟೆನೆನ್ಸಿ ಆಕ್ಟ್ ಅಲ್ಲಿ 12 ಎಕರೆಗೆ ಅಪ್ಲೈ ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದು. ಇದು ಒಂದು ಕಾಪಿಯಲ್ಲಿ ನಾನು ರೀಡ್ ಮಾಡ್ತೀನಿ, ಒಂದು ನಿಮಿಷ. ಈ ಲಾಸ್ಟ್ ಕಾಲಮ್ ಅಲ್ಲಿ ಇದೆ. ಸುಮಾರು 18 ವರ್ಷಗಳಿಂದ ಸಾಗು ಮಾಡುತ್ತಿದ್ದೇವೆ. ನಮ್ಮ ತಂದೆ ತಳವಾರ್ ರಂಗಪ್ಪನವರು ಪಾವತಿಯಾಗಿರುವುದರಿಂದ ನಾವು ಪಾವತಿಯಾಗಿರುತ್ತಾರೆ. ನಾವುಗಳು ಒಂದೇ ಕುಟುಂಬದ ಸಾಗುವಳಿದಾರರಾಗಿರ್ತೇವೆ. So, next my colleague not present.
No, my lord, what, sorry, lordships, to interfere.
Next week.
Tomorrow will take.
Tomorrow. What he is reading is, my lord, his document.
Understood. Anyway, he has to make his submissions. This is matter tomorrow at the request and counsel the respondent.
Alupatti, your lordships had sought me for the
I've seen that as
Tulsidhara judgment, Supreme Court.
the judgment of the Supreme Court.
Tell number 40. Then Jayadeva for petitioner, Kashyap and Nayak for the.
Hearing for the respondent in this matter, my lord.
Who appears to the petitioner?
Jayadeva.
I pose the petition, my lord.
Yes. Yes. He wants a paper.
Is a partition suit, my lord. The preliminary decree was passed. Now they filed an application for final decree, my lord. In the meanwhile, I had preferred an appeal. In the appeal, the shares were changed, my lord. In the first instance, between the siblings, one-third share was allotted for 3 siblings. One of the siblings was a spinster, she died. And after the matter was taken up in appeal, it was said, in view of the death of one of the sisters, each of them will have half share. The decree was modified. The proceedings initiated are in respect to the original first decree of the civil court, not of the appellate court. I took a stand saying that the FDP proceedings are not maintainable because it is in respect to the first decree that was passed, which has merged with the second decree passed by the High Court. That has not been taken note of. My application has been rejected, my lord. Against that, I come.
That's page number.
Page now.
Lord, that order sheet starts at page number 69, my lord. The reasoning starts at page 5, my lord.
You are
Para
read
5,
as?
para 5, my lord.
You are plaintiff.
Dependent.
No, I was the defendant in the original suit, my lord.
Defendant. What was the original decree? Granted
Original
matter
decree
or-
was 1/3 share to each of the 3 siblings, my lord.
Against that you preferred appeal.
I preferred an appeal.
Pendency of appeal, one of the defendant died.
One of the defendants died,
So now you are, that is altered to half of.
half of share, my lord. In the first instance,
Then when did you file the FDP? Before
I was the one who
judgment?
preferred an FDP, my lord.
Huh?
I preferred an FDP. When the suit got decreed in the year 1993, my lord. Thereafter, when the RFA was still pending, my lord, I had preferred an FDP because there was
So
no
what
stay.
Now, in the light of the orders passed in the RA,
Yes, my
what
lord.
will happen to those proceedings?
My lord, the FDP is continuing. The initial FDP, what I have filed is continuing. The court has taken note of the findings of the Honorable High Court in the RFA, where the share got changed from 1/3 to 1/2. And accordingly, the court has passed an order saying that both the siblings, now there are only, since there are only two surviving siblings, the property should be divided equally among both the siblings. But the contention of the petitioner here is that since I had filed a FDP prior to the RFA judgment passed in RFA, then that FDP should entirely go, and I am supposed to file a new FDP, which is my lord, in my respectful submission, there is no provision
No,
of
going-
that sort.
what is your difficulty? Your half share, what is granted by virtue of the judgment and decree in RA, that will be taken forward by the
No,
court.
madam. In the meanwhile, my lord, while disposing of the RFA,
Hmm.
I had taken a contention that I had redeemed the mortgage that had been created by my mother, and that has to be adjusted whatever money that I spent.
Where is that order in the RA? Let's,
RFA is there, my lord. At page 48, my lord. At page 48, the relevant portion is there, my lord. Internal page 12.
please read.
It was strongly contended that defendant number 1, after the death of the mother, he redeemed the mortgage in 1983. Hence, the properties deemed to have been gone to the defendant number 1 exclusively, though it is a contention of the defendant number 1 that he had redeemed out of his self-acquired income. Except a bald statement, there is nothing on record to show that it is redeemed by his own contribution, but the fact remains that it is redeemed. Redemption of mortgage does not disentitle the plaintiff from claiming a share in the property. As such, when the facts are not in dispute, Ramaka was the owner of the property and she died intestate, leaving behind the plaintiffs and the defendant number 1. They being the only 3 legal heirs, they are entitled for equal share and there cannot be any dispute on this aspect. As such, the trial court has rightly decreed awarding 1/3 share each. It is now submitted that plaintiff number 1 died, and if she has died, her share has to be divided amongst plaintiffs number 2 and defendant number 1, subject to adjustment, if any, in the final degree proceeding. The adjustments, if any, refers to the redemption of mortgage, my lord. I spent money, that has to be accounted for. For that, I have to lead evidence. I sought for permission to lead evidence. The Honorable Trial Court has rejected my application. I come before my lord. This is the adjustment, my lord.
No, that is not what you wanted. You said that it is, the proceedings are not maintainable. Where did you ask the court?
No,
that-
I am
that
stating
has to be-
one stand I have taken is petition not maintainable because it is in respect of preliminary decree that gave only one-third share each. Now the decree has been altered to half
That is
share.
what is going to be
No,
executed.
the
by court.
consequential, they had to file a fresh petition, my lord, because that original decree.
That's purely a technical one. Then what about, where did you ask the court to, with regard to the leading of evidence?
Yes, my lord.
And what is the finding of the court on that?
Page 74, my lord, 73, my lord,
Yes.
73, para 7 of the order, my lord, of the trial court. I'll read that particular portion. It is very pertinent to take into consideration the entire reasoning in para 10 of the para 16 RFA, whereby the Honorable High Court of Karnataka had clearly held that though it is a contention of the defendant number 1, that's what has been extracted. The same paragraph has been extracted, which I led to my lord. As such, the kindly decreed the suit, awarding 1/3 share each. Next, my lord, para 8. The finding of the Honorable High Court of Karnataka in RFA clearly makes out even if there is redemption, it does not disentitle the plaintiff from claiming share in the property. Respondent number 1 who had filed the application or the counsel who appears to respond number 1 might not have read out this finding or understood it in the right sense, though there is a clear finding in RFA in para 16 of the RFA number so and so. The respondent number 1 had come up with the present application when the property is auctioned for sale, alleging that the petition itself is not maintainable. Enquiry has to be conducted regarding the adjustments as observed by the Honorable High Court of Karnataka, and fresh petition for drawing up a final decree has to be filed.
Where is the decree?
Decree, my lord. High Court decree I have to do.
First document. Yes, 50.
Page 50, my lord. It starts at 49, 50. but relevant portion is 51, my lord. The bottom portion, my lord. It is further ordered and decreed that if plaintiff number 1 dead, her share has to be divided amongst the plaintiffs 2 and defendant number 1, subject to adjustment, if any, in the final decree proceedings.
What do you say? What do you say on this?
My lord, my lord, with regard to this, my lord, see, clearly the High Court has given a finding saying that just because he has, although it has categorically held, there is no material on record to show that he has redeemed the market. One, assuming that that he has redeemed the mortgage, my lord, it is close to about 14,000 rupees, my lord. Just for proof, let me concede, my lord, let him take that 14,000 rupees as and when this property is auctioned, that I am ready to give up on that 14,000 rupees. Let that not hold back the entire FDP proceedings merely because he has some 14,000 claim on the property because he has redeemed the mortgage. My lord, it's a 1993 suit and 30 years has lapsed and the lady is and he is enjoying the rent. In fact, there is a trial court order in 2007 that he has to deposit the rent before the trial court. He has completely ignored it. For last 25 years, he's been enjoying the rent exclusively. Now he wants to adjudicate.
Then we'll record that as far as redemption of whatever the charges for redemption of the mortgage.
Yes, my lord.
Let the court decide it and proceed with the matter.
My lord, let me go one step, my lord. Let that redemption of mortgage, he is saying 14,000. I am ready to give up on that. Let my statement be taken on record. When the property is auctioned, let him get additional 14,000 rupees. I don't mind. Because of which let there not be another trial, him leading evidence, delaying it for another 10 years to enjoy my right in the property.
Rupees, my lord.
Huh?
Money was spent in 1983, my lord. I was working.
What about the rent that he has been enjoying, my lord? Can I claim that?
I saved every rupee.
Despite there being an order from the court in 2007, where has he deposited the rent? Let him demonstrate his bona fides before the court. In my statement of objections, I have produced the copy of the order which is passed by the trial court asking him to deposit the rent, my lord.
Well,
can he show that?
If an inquiry is conducted, my lord, I'll be able to prove what money has spent, what is the benefit the value addition is there for the property. That inquiry has to be done. That's what I'm seeking, my lord. If the inquiry is ordered, I have no issue, my lord.
Even about that rents and all which you have not deposited, let that also be an inquiry on.
No, that property not, it is in a dilapidated condition, no tenant is there, nothing is there, my lord. If property is brought to auction, nobody came to purchase the
then
property.
let me occupy that, possession of the property, my lord. I am happy to occupy it tomorrow.
In fact, my lord.
Let them hand over the possession to me. I will occupy it. In fact, whoever the tenants I am going to induct in that property, I am going to pay half the rent. Let my statement be taken on record.
My lord, in this, there is a small portion that has been subject matter of another suit, my lord. Because of that, nobody is coming forward to buy the property, nobody is entering the property, is dilapidated.
Not subject matter of this particular decree at all, my lord. That is a neighboring property.
Council, please wait.
I'm sorry, my lord.
My lord, the property may be more than 100 or 150-year-old, my lord. There is nothing there in the property. No tenants are there. I am there. Even my wife is also passed. Me and my son are there in the property. And what I am seeking for inquiry and let the property.
From 2019 till now.
No, I am not asking for any time, my lord. I am not asking for any time. I said, let the matter be decided. Let the inquiry be conducted. I will permit lead evidence regarding the value addition. Then let it be decided, my lord. The property be auctioned. Nobody is coming forward to buy the property.
How much you want? How much time you want for that?
Pardon?
How much time you want for that?
Anytime, whatever time the court fixes.
The judgment and decree in the RFA.
Pardon?
When was the judgment and decree in the RFA?
RFA was in
2012, my lord.
2011, 2012.
12 to 12, we are in 2025. And ultimately,
I am not stopping the proceedings, my lord. I am not stopping the proceedings. I always go, even for the purchase, auction sale also nobody came forward to buy the property. Now let your lordship be fixed 3 months time for evidence to be recorded. I'll go ahead, man.
No, my lord, I strongly object to this, my lord. Let the inquiry happen parallelly, my lord. I have no objections for the inquiry as he is requesting. Let the inquiry happen parallelly, but let the sale or auction proceeding should not stop because I have been waited 30 years And we have tried all means to
Let it
arrive
go.
at amicable
One of my
settlement. my
cousins
lord.
has, one of my cousin has filed a suit.
Let auction proceedings go on and let the court, as far as this inquiry with regard to what you are entitled, let the court do.
Ah.
And accordingly, whatever the amount comes, that will be apportioned.
Yes,
But
my
the
lord.
inquiry
I am
regarding the
agreeable to
redemption of
that
the mortgage.
proposal.
And let the inquiry go on.
Let the inquiry go on, my
Inquiry
lord.
not say all, sale also go on.
Yes, my lord.
Let the inquiry,
both
let
go
the
on.
inquiry, my lord, sale, I mean, I not come in the way of sale, my lord. What happens is the
You
court,
can't have both. You can't have both.
let the inquiry be ordered, my lord. Let the inquiry be ordered.
Go on and let the sale also be not stalled.
Let the inquiry be ordered, my lord.
Let the inquiry be time bound, my lord. Let him not take his own sweet time to lead the inquiry because
Please come, very impugned order is at page number? Agreed with the orders passed in I number 2 in FDB number 27 of 2020, 2004, dated
There's
19/7.
one more thing, my lord.
Yes,
There's one more RFA pending, my lord.
19/7/2009, 2019. The petitioner is the defendant number 2, defendant number 2 in the suit is before this court. The respondent herein has filed a suit for partition, which came to be decreed, whereby the plaintiff and the defendant were granted 1/3 share. Thereafter, the defendant number, you are 1 or 2?
One.
Defendant number 1 had preferred. Where is that order?
RFA number
Has
Three.
filed RFA number
1311.
1311 of 2003. And during the pendency of the RFA, defendant number 2 died.
Defendant number 2 died.
Defendant number 2 died, and the appeal was decreed.
sorry, my lord, it's a plaintiff number 2. We are the co-plaintiffs.
Plaintiff number two.
Plaintiff number 2.
Plaintiff number 2 died. And
Plaintiff number 2.
and the court, then both the plaintiff and the defendant were granted half share. In the RFA order, there is a mention about the defendant redeeming the mortgage. In that, the court has observed that the trial court has rightly decreed awarding 1/3 share each. The plaintiff, it is submitted that plaintiff number 1 died. If she has died, her share has to be divided among the plaintiff number 1 and 2. The plaintiff number 2 and defendant number 1, subject to adjustment, if any, in the final decree proceedings. Even before the RFA is filed, the plaintiff had initiated the FDP proceedings. That is FDP number 27 of 2004. Now the present IA is filed. That's IA number 11 is filed by the defendant to defer the auction sale of item number 1 of the property till consideration of his objections regarding maintainability of the petition, and if maintainable, till inquiry is conducted regarding adjustment as observed by the High Court in RFA number 1311 of 2003. The court, by order impugned, had dismissed the said IA.
At page 70.
And observe that if the mortgage amount is paid by first defendant, that is an amount of rupees 13,300 can be adjusted if the document is produced with regard to this payment, if admitted by the petitioner. And for this purpose, once again, inquiry is not necessary unless and until this amount of the amount of rupees 13,300 we get adjusted from the sale consideration. If there is no objection for such adjustment on behalf of the petition number 2. Further, with regard to the maintainability of the FDP proceedings, court has also negatived the same, that the court now considering the judgment in the first appeal, where half share is allotted to the plaintiff and the defendant, is proceeding with the matter, has observed that such objection cannot be sustained. and accordingly dismiss the aggrieved thereby. The defendant number 2, the defendant number 1 is before this court. Then counsel appearing for the petitioner submits that when the FDP proceedings are initiated as per the judgment and decree passed in the suit, whereby 1/3 share is allotted to the parties. Now, when whenever judgment and decree is passed, and the earlier, when that is merged with this judgment or decree, the FDP proceedings cannot be continued on the earlier judgment and decree. It is submitted that when it's the case of the defendant that he had redeemed the mortgage and paid an amount in the year 1980.
3 million.
83, unless and until an inquiry is conducted, what is the amount that he has spent? And as these many years have passed by, and what is his entitlement, court cannot proceed with the same. The court, without considering all these aspects, has dismissed the petition. Next para, learned counsel appearing for the respondent plaintiff submits that only with the delay tactics, these kind of applications are filed by the plaintiff. He submits that the FDP proceedings are going ahead basing on the judgment and decree passed in RFA. Further, the defendant is enjoying the property in spite of an order passed by the court. He is not depositing the rents before the court. It is submitted that he has no objection to if that whatever amount he has spent for the redeeming the mortgage, if the same amount is paid to the defendant.
Same amount plus interest and all will come, my lord.
That's my submission.
If the amount is paid to him, he has no objection. It is submitted that now by virtue of the stay granted by this court, the entire sale proceedings are state and sale proceedings are state. He submits that the court had rightly observed that no inquiry is required as requested by the petitioner herein. He submits that all these these proceedings are initiated only for stalling the proceedings, and though in 2012 a decree is passed, they are not able to enjoy the fruits of the decree even till now. Next para. Having heard the counsels on either side, there is the material on record. No dispute about the fact the FTA was initially initiated after the judgment and decree passed by the trial court. Thereafter, RFA is filed, and in the RFA, the court had observed that as the plaintiff has died, one of the plaintiff has died, now the defendant and the plaintiffs are entitled for a half of the share. Then in the final decree proceedings, when the property was put to sale, auction, at that point of time, this defendant number 1 had come before the court with this application on the maintainability, and the second that an inquiry needs to be done in respect of the amount he spent for redemption of the mortgage. As far as his first objection is concerned, with regard to maintainability, in the considered opinion of the court, there are no legs to stand, and the FDP proceedings are very much maintainable. Then coming to the amount that he has spent for redemption of the mortgage is concerned, the court ought to have conducted an inquiry. But for conducting an inquiry, the sale proceedings need not be stalled. Considering all these aspects, this court is passing the following order. The order of the trial court, the order of the court dated so and so is set aside. Not set aside, the writ petition is disposed of, directing the trial court to conduct an inquiry, and the petition shall cooperate and complete the inquiry within a period of 2 months from the date of receipt of the copy of the order. Number 2, as far as the auction of the properties are concerned, the same shall go on accordingly disposed of.
Cell number 41.
Much obliged.
Kumar Vijay Kumar for petitioner. K. Anand for respondent 1.
Chairman,
Yes.
Lord, may I seek a week's time to produce the translated copy of the order, impugned order? It's in Kannada
It is
version.
submitted to the
Kannada version.
Fourth occasion he took an urgent.
I don't
One
mind
or the
that,
other
I'm
go.
ready to argue.
Sorry to my
Subject
lord,
with regard to
my
the
learned
previous-
friend is not opening the file today only. He opening the file from the beginning. From the one or the other reason, my lord, he gave and it goes on.
Oh, whatever is
Please.
his reason, how do you expect the court to understand?
Please, that's what.
Land counts for the petitioner submits that the impugned order is in Kannada. He shall come up with and he will file the transcribed copy may not be required. This is matter on 3rd of March.
Acha.
Number 42. CM Nagbhushan for petitioner.
Wait for a short time, my lord. It will be taken on Saturday or Monday, my lord.
Respondent, my lord, 1 to 5,
Let's see what happened on the last occasion.
short time, they start. And one time not represent.
Was this matter on 29/1? Then also the petitioner or respond delete from so and so. Why you want time?
My lord, senior is on decks. He was here only, my lord. There was a matter, part-heard matter reaching, my lord. It may be
How
kindly,
many times you can seek for adjournment like this?
my apologies, my lord. Monday or Saturday.
We will adjourn, but interim order will not be extended.
My lord, it may kindly be taken tomorrow, my lord, or at least kindly pass over, my lord.
Tomorrow, interim order is extended. Interim order will not be extended on the request. It will not be required, it will not be extended at any cost. If the, on the petition shall go ahead with the matter tomorrow. Yes, 43.
Still number 43.
Previous matter, there is.
Previous matter, if interim order is there extended. Yes, 43.
43.
Subject to some conditions. Goes on, he taking extension.
No.
Okay.
Next, even now we are ready, but for that Kannada language.
43.
Jairaj DS for petitioner.
I'm appealing for
Bhargavi.
respondent.
As for the respondent is present, no representation for the petitioner. This is matter on 28th of April, not to extend the interim order.
Still number 44.
I appear for the petitioner, ma'am.
Chandran.
I appear for respondent number 1A, please, my lord. My lord, I request for a week or two, my lord, at time. My lord, I'll produce the copy of the issues, please, my lord, and I may be permitted to address arguments. Issues would be relevant for that reason, please.
So why have you not come with the relevant things?
My lord, in fact, my lord, I was not keeping well, had some difficulty, that's the reason.
At the request of land council, respondent lists matter on 10th of March.
Still number 45. 45.
For the respondent, consider my lords in this matter.
My lords, last occasion, my lords has sought for production of the relevant document which are relying the amendment, my lords. I'm producing the sale deed, which is marked as exhibit P1.
What is the impugned order?
Lord's impugned order is that, my lords, during the, at the time of cross-examination of, or at the time of evidence, my lords, the plaintiff filed an application seeking to amend the number of the scheduled property and also one boundary extent, my lords.
For that I wanted to look at the.
Yes,
slide.
my
Yes,
lord.
my lords.
That is the exhibit P1, my lords, but that is a Xerox copy. It is in Kannada.
Where do you get the date?
My lords, date is at the page now, first page, my lords, in the immediately after memo, my lords. First page of the 12/2/2004 sale deed date.
No, this date you want to incorporate.
Yes, date,
Not
not
date,
date,
my
my
lords.
lords, sir, number,
In the
property number.
third pair of the very same page,
In the schedule, my lords,
Mentioned-
last but one page, schedule.
123A. My lords, in the they have stated, the plaintiff has stated that the scheduled property is bearing number 121A.
Oh, that's basing on a document. How does it matter now?
My lords, it matters that to my lords, till the, my lords, the own.
The whole basis is a sale deed. It is more or less a typographical mistake.
My lords, even if it is a typographical mistake, the last date of hearing, I intended to rely on the judgment of the Honorable Supreme Court. Even it is considering the typographical mistake. Even at the time of the trial also, even if he seek for the amendment, the person who is seeking for the amendment of the plaint or the portion of the any of the amendment proposed to be sought, he has to establish his bona fide that he was not unable to propose that amendment. Here, even at the time of evidence, PW evidence was commenced. He was also cross-examined.
Pass on the judgment.
My lords.
Pass on the
Please, ma'am.
judgment. Please come. The application is agreed with orders passed in IA number.
My lords, IN number. I number 5, my lords.
I number 5 in OS number 8021 of 2017 dated 14/10/2011. What is the date?
17.
14/10/2017.
My lords, the OS number 8021 of 17, IA date, my lords, 23
19.
2019.
Hmm?
23/8/2019.
23/8, it appears on 14/10/2019.
Order is on 20, please.
14/10/2019.
Yes, ma'am. 14.
19, the plaintiff is before this court. The plaintiff had filed the instant IA and order 6 rule 17 to amend the plaint. It is his case that he is the owner and in possession and occupation of the property site bearing number 123A, assessment number 6, Kata number 59, situated in Lagare village, Yeshwantpura. At the time of filing of the suit, due to oversight and typographical error, the property number in the plaint in para number 2 in the line number 3 was wrongly mentioned as 121A instead of 123A. And further in the scheduled boundary, western side is wrongly mentioned as conservancy, and thereafter site number 160/2 is of site number 160/2. Accordingly, they filed the present application seeking amendment to the same. The court had dismissed that application, observing that on a perusal of the entire record, it is clear the suit of the plaintiff is one for permanent injunction against the defendants from interfering with the peaceful possession and enjoyment of the property. Already the issues are framed in the case, and the case is posted for further chief examination of DW1. At this juncture, this application is filed by the counsel for the plaintiff for amendment of the plaint as well as boundary, as rightly contended by the counsel for the plaintiff. Pretrial amendment or normally allowed, and any application filed after commencement of the evidence will not be allowed. In the present instance, already the matter was posted for cross-examination of DW1. Further, the plaintiff in the amendment application sought for the change of the survey number as well as sought for the change of the boundary. If this application is allowed, certainly it will then change the entire nature of the case, and also, once again, additional issues have to be framed for the purpose of leading the additional evidence to the plaintiff.
My lords, one
And
cross
the-
of DW1 is also almost done, my lords. That may kindly be noted on it.
I'm looking at the order. In your contentions, I'll record.
Please.
So accordingly, dismiss the application filed by the plaintiff. Agreed thereby, the plaintiff is before this court. Land counsel appearing for the plaintiff submits that he is according to the plaintiff, he has purchased the property by way of a registered sale deed dated 12/2/2004. In the registered sale deed, the boundaries and the survey numbers are mentioned, and is asserting his title and possession to the property by virtue of the said sale deed. When it comes to the plaint, the survey number is wrongly mentioned and the boundary is wrongly mentioned. Thereafter, they have filed the application for seeking amendment of the plaint. Land counsel submits that the court, without considering the fact that no prejudice would be caused to the defendant, and if the said amendment is not the amendment is not allowed, it would cause a lot of prejudice to the plaintiff. That aspect was not considered, and the court had dismissed the IA. He submits that if the order needs to be set aside. Next para. Land counsel appearing for the defendant submits that after the defendant one was cross-examined.
Yes, my lord.
Cross-examined, at that stage, this application is filed. Now, by virtue of this amendment, they're altogether introducing a new case, and it would change the entire nature of the suit, and it would cause prejudice to the plaintiff. He submits that once when the application and order 6/17 is filed after the commencement of the trial, the burden lies on the plaintiff to show that in spite of due diligence, all these aspects were not brought to the notice of the court. He submits that in the affidavit, he has not stated anything and without there being such a pleading and for the lapses on the part of the plaintiff, the defendant cannot be punished and it would cause a lot of hardship and prejudice to the defendant. He had relied on the judgment of the apex court in Pandit Malhari Mahale versus Monica Pandit Mahale and others, reported in 2011 SCC 549.
In the last,
And he has relied on
last parameters. The Supreme Court extracted judgment of the
para number 8. He
Please.
relied on para number 8, extract that. Relying on this judgment, and counsel submits that the court had rightly dismissed the application and no grounds were made out. Next para, having heard the counsels on either side, peruse the material on record. The present application is filed, seeking amendment and order 6, rule 70. The suit is the suit is filed seeking injunction, but mentioning the survey number and the boundaries. After the commencement of the trial, the defendant has come up with this application where he
plaintiff, my lords.
plaintiff has come up with this application where he sought to amend the plaint by changing the survey number and the boundaries. According to him, it is a typographical mistake. This court has perused the sale deed basing on which he is asserting title to the property. In the sale deed, what the numbers that are mentioned and the boundaries that are mentioned is the same thing which he wants to introduce by way of an amendment. No doubt, the same facts, this step should have been taken by him with regard to this typographical mistake at a earliest point of time. Here in this case, it does not amount to introducing a new case for the reason the whole basis of his pleadings is about his title to the property basing on a registered sale deed. And now the boundaries and other things, what he is mentioning is basing on the said, basing on the survey numbers and the recitals and the boundaries that is mentioned in the said sale deed. While though after the commencement, in spite of due diligence, that the burden lies on the plaintiff to show that in spite of due diligence, he could not bring all these facts to the notice of the court. At the same time, the courts have to look at the substantial justice and the prejudice to the other side. And when the pleadings itself are based on the said agreement, sale deed, and this amendment that is sought is in consonance with that, this court is of the view that the court ought to have allowed the application. Hence, this court is passing the following order. The order dated so-and-so is set aside. And the petition is permitted, the IA filed by the petition plaintiff is allowed. Number 2, on the, on the condition that he shall pay an amount of rupees 5,000 as cost to the defendant.
May I request your lordship to also kind of give a direction to dispose of the suit as expeditiously as possible, as it is 2017 suit, my lords. At least as
2017 suit. Then what about people who are suffering
Just-
2005?
just a submission before lordship.
Because at this stage we can't. Yes.
Please, my lords.
Cell number 46,
Yes.
retired petitioner.
Any stay?
No, there's a stay.
Oh.
Actually, what has also happened there, my lord, is that the petitioners herein are coming at morning 10:30 AM and they make a incorrect submission stating stay was not continued. I can even produce the order sheet, my lord.
No, anyway, they're not, they will not continue it.
And one more aspect in this matter, my lord, is that in the execution matter, my lord, it comes to be filed in a Bangalore court. Just in 2 minutes, I'll be able to narrate the history of the case, my lord. My lord, I have filed an order.
Yes, but the difficulty is court cannot pass any orders. One thing I'll clarify is that this court is not extending the stay.
No,
And the
please, my
court
lord.
can proceed with the matter.
I bow down to that. Only one submission, my lord. OS number 118 of 2016 is filed at Budwell Court in Andhra Pradesh, my lord. Thereafter, my lord, an ex parte judgment and decree comes to be passed against the petitioner. They do not file any application to set aside the ex parte decree. Thereafter, my lord, I prefer an execution petition before Andhra Pradesh. What happens is that I get to know that the properties are in Bangalore. So I prefer a transfer petition there. Execution petition is transferred on the file of the court of the Bangalore District and Sessions Judge. Here, my lord, they filed this petition and they've got a stay, even without challenging the original suit to set aside.
I heard this matter, I think. I heard it.
No, my lord, it's the first time it is coming up.
It's not about the Legal Service Authority.
No, it's not about legal service authority.
No representation for the petitioner. Counsel for the respondent is present. List this matter tomorrow for dismissal.
And the interim order is not vacated, positive
No,
order.
I'll not, tomorrow I'm.
Yes,
taking
please.
this part. Tomorrow, don't extend the interim order.
Grateful.
Yes, 47?
Case number 47, TJ Sunka.
I'm offering for petition.
Petitioner,
Yes.
E. Malaswamy for respondent.
Counsel for the petitioner is present. No representation for the respondent. List as
Interim order.
parted on 4th of February.
Interim order extended.
Interim order earlier granted is extended.
Case number 48, final hearing, H.N. Basavaraj,
Would it be taken up Monday, my lord?
Swanand Mehti.
I am appearing for respond.
I'm for the petitioner.
Whom he is appearing?
I wanted to make a submission.
On what?
In which matter?
My matter, 21st matter, just I missed.
What happened to that?
And now it is adjourned to April, but interim order is there. But any day, if your lordship post it, I will appear.
Interim order is extended, court would have not.
No, not for
granted it
that
to April.
period, not for that period, my lord. Day of tomorrow. Day of tomorrow, I will
First,
appear.
item number 21, list this matter. Day after
21.
tomorrow.
21, my lord.
21, list the matter day after tomorrow, stay is extended till then.
And I have told the other side also.
Yes,
She was here.
yes, yes.
I am sorry, my lord. I could not. I was in the-
Anyhow, yes, 48.
48,
Would it be on Monday, my lord? No inconvenience, my lord. My senior is held up in 24. He'll come, my lord.
In this matter, this is a suit for 2007.
No, it is now we are on adjournment.
Leave to the court. Leave to the court. I can't oppose
This matter on
next week.
5th February.
Please.
Much obliged.
Call that matter, the dictation one,
yes. That.
what 49?
My lord, instead of 5th, my lord, could it be on 6th? 6th, my
No,
lord.
6th.
Please. Much obliged.
59.
My lord's permission. Serial number 49, my lords, there was an interim arrangement granted by my lords.
Where is other?
I in fact messaged, they thought it is at 5 PM. That's the reason. I messaged them.
We'll have it tomorrow then for the orders, not at 5 PM.
Please,
Let it be in the list tomorrow. In
Grateful.
their presence will pass on.
grateful. Grateful.
49, tomorrow. This is matter tomorrow, not in the chambers,
Grateful. My lords, it's not in the chambers. It's before your lordships today in the court.
5 PM.
Yes. It's
No,
part of-
generally they might have missed 5
Please.
PM is in the
Let-
chambers,
it-
they might
it
have.
may be in the court.
Tomorrow, not 5 PM, tomorrow. List the matter tomorrow.
Grateful, ma'am.
Yes.
Grateful.
List number 2,
Oh, there's one more list.
yes.
Mm.
List number 2. Parted, serial number 1, Kumar K.R. for petitioner, appearing there.
Petitioner, my lord, please kindly pass over, my lord. Senior is in another court.
At 420, what passovers you expect the court to do? Let this list come tomorrow, we'll see. All the entire list tomorrow. Please call that, the
Interim order.
This,
For memo, for dismissal.
on request, this matter may be called on list 1 in this matter because
So it will, because now it won't come in list 1, because already, it will come in list 1 if tomorrow,
If tomorrow.
then tomorrow, all will come in list 1 only. Parted
Interim, list two interim orders may be kindly extended. All these
1,
two
2,
matters.
3, look at it. All these matters tomorrow parted and in interim order is there, extend. Then 4, what about this?
For the petitioner, my lord.
1 minute, I'm calling.
Serial number
Dismissal, what
4,
you did, you said
For the
something.
petitioner, my lord. We are ready. So apologies, my lord. Yesterday senior was held up in the, we are ready, my lord.
Yes, this matter also delete from caption dismissal. Let it be tomorrow in the list. Yes, next, B group
5, B
Madam,
group.
I prefer the petitioner, madam.
in 5.
Yes, ma'am.
It's an early hearing.
Early hearing, my lord, there is only appointment of a commissioner. I got straight my own suit.
Tomorrow we'll hear it.
Yes,
Let
ma'am.
it be listed tomorrow, 5.
Serial number 6,
6, my lord, yesterday it was heard, my lord, regarding, my lord, amendment of my lord, pleadings.
Tomorrow,
Last,
let it come tomorrow, 6. If, in all these matters, any interim order is there, extended 7 and 8 also, tomorrow. 7 and 8 tomorrow, if interim order is there, extend.
Yes, ma'am.
Now call that matter for,
Number 4,
for judgment.
list
File
1,
also
serial
file.
number 4,
Wherever interim order is there, it will be extended. Yes.
list 1, serial number 4,
Please, ma'am, for responding.
Do all those with notes and all. Where is the impugned order? Agreed with orders passed in execution number 10 of 2006, dated 23rd of August 2017. The judgment letter is before this court. The respondent herein has filed a suit for specific performance of an agreement of sale dated 25/25/1989, which came to be decreed, which the suit was decreed on 30/11/1998. Against that, the defendant has preferred RA number 224 of 1999, which came to be dismissed on 13/7/2005. Thereafter, the decree holder had filed the execution petition on, that is execution number 10 of 2006.
Correct. 23.
On 23/2006. Thereafter, on 24/11/2014, the judgment debtor has filed a petition under section 28 of the Specific Relief Act seeking rescission of the contract. That came to be dismissed by order dated 23rd August 2017. While dismissing the application, the court has observed that it is a contention of the decree holder that after contest the suit in OS number 268 of 19, no, it is for that, it is a case of the judgment debtor that though the EP is filed and an amount of rupees 5,000 is yet to be paid by the decree holder, but he has not yet deposited the amount. In that case, he is not entitled for the specific performance of the contract. It is a case of the judgment, the decree holder that neither in the decree, in the decree that is passed, there is no mention about the time frame when the amount has to be paid. As such, the section 28 of the Specific Relief Act do not come to the rescue of the decree holder. The court dismissed the application and observed that when the decree is silent as to deposit of balance sale consideration amount, as it is well settled principle that the executing court cannot go beyond the decree. As such, question of entertaining the application under section 28 of the Specific Relief Act does not arise. Even though the decree holder has filed the execution petition in the year 2006, till 2014, the JDR is kept quiet, and in the year 2014, he filed the IA to resign the contract. The said aspect goes to show that the JDR, with an intention to drag the proceedings, filed the present application, and there are no reasons assigned by the JDR to allow IA number 1. Next para. Learned counsel appearing for the judgment debtor submits that he has denied the fact that the contract is agreement is executed. The suit is decreed and the appeal is dismissed. And even after the dismissal of the appeal on 13/7/2005, in the year 2023/2006, execution petition is filed. But the plaintiff, but the decree holder has not paid the remaining 5,000 rupees. and he has filed a petition for rescission of the contract. It is stated that at any point of time, even till now, they have not paid neither they have paid the amount, nor an application is filed seeking extension of that time. When they have not done either of the two, they are not entitled, they cannot seek specific performance in the court ought to have rescinded the contract. The learned counsel had relied on the judgment of the apex court in case of TL Rajagopal versus SN Shivakumar, reported in 2014, SCC Online, Karnataka, 10072, paras 13, 17, 23, and 25. Extract those paras. Then he has relied on Prem Jeevan versus K.S. Venkatraman and others. Extract para number 8 and 9. He had relied on Shyamala, another judgment of the apex court in case of P. Shyamala versus Gundodu Mastan, reported in 2023 SCC Online 184, para number 24. Relying on these judgments, learned counsel submits that the trial court had erred in dismissing the application filed by the judgment debtor under section 84 of the specific relief act. Next part. When a senior counsel appearing for the decree holder submits that the decree holder and the judgment debtor are none other than the decree holder is the brother-in-law of the judgment debtor. As per the case of the plaintiff, an amount of an extent of in respect of an extent of 1 acre 30 guntas, where it was agreed to sell, where the defendant has agreed to sell for an amount of rupees 30,000, payback on 2/5/1989 itself, an amount of rupees 25,000 is paid. The remaining amount that needs to be paid is 5,000. The judgment and decree is silent with regard to the payment, with regard to the balance sale consideration and when it has to be paid. The suit was decreed with costs of rupees 3,158 and the appeal is dismissed with costs of rupees 1,149. If both these amounts are paid, what is left in that 5,000 is 6,995.
6,693 rupees.
693 rupees. Then a senior counsel has drawn the attention of the attention of the court to section 28 of specific relief act, and drawing the attention, the senior counsel submits that as per the section, there should be a stipulated time, which is not present in this case. And second, the court has to look at the substantial justice where the relief of specific performance is a equitable relief. The court has to look at the conduct of the parties. Having executed an agreement of sale in the year 1989, in the year 1992, he sells the property. 1992?
92, my lord.
He sells the property in the favor of his wife. And after the suit is filed, the wife sells the property in favor of the sons, and the sons in turn sells the property in favor of third parties. And those third parties have filed the petition, objection has filed an applications, that is order 21 under order 21 rule 97 in the execution. And those petitions have taken a lot of time. And even now, as far as one objector is concerned, both the IAs are dismissed, and in respect of one objector, RA number 50 of 2013 filed by them is dismissed. And other is pending.
Other is, there is no appeal, only one appeal.
Is dismissed. It is submitted that all these things demonstrate the conduct of the defendant, who have, during the pendency of the suit, one after the other, the sales have taken place. And when he has no interest in the property where his wife and children have sold the properties in favor of third parties, he comes up with an application for seeking under section 28 to resign the contract. It is submitted that the court has to look at the conduct and in terms of justice, he is not entitled for any relief. It is submitted that the judgment that are relied on by the land counsel for the petitioner do not apply to the facts and circumstances of the case. And further, in those cases, it's an ex parte decree. And further, the finding of the court supports the case of the decree holder. It is submitted that further in those cases, substantial amounts where the balance sale consideration is a substantial amount. Whereas in this case, it is only 693 rupees. For an amount of rupees 693 rupees, the contract cannot be rescinded, and the court has to look at the substantial justice of to the parties. Next part. Having heard the land counsels for the petitioner and the land senior counsel for the respondent, there is entire material on record. The suit is decreed on the admitted facts in this case, or the suit is decreed on 30/11/1998, and against that an appeal was preferred, that is on 13/7/2005. Neither there is no time frame that is fixed in the judgment and decree for paying the balance sale consideration. Then execution petition is filed on 10/23/2006. Even on 23/2006, the the decree holder has not paid the remaining sale consideration, and he has filed the EP. Then seeking rescission of the contract on 24/11/2014, an application is filed. Even at that point of time, the amount that is due, that is the part of the sale consideration, is not paid by the decree holder. Thereafter, it is submitted before this court during the course of argument that in the year 2018, an application is the memo is filed that they are ready to deposit the remaining sale consideration. The argument of the learned senior counsel that as the decree is silent, as there is no specific time, section 28 of the specific relief act is not attracted. That particular submission, this court is not able to appreciate, and it has no legs to stand. Just because the decree is silent about the time frame, that doesn't mean that the decree holder eternally will wait and will not deposit the amount. Even when an application is filed for rescission of the contract, even at that point of time also, the decree holder is not even vigilant, and he has not even taken steps to pay the amount. Whether it is a substantial amount or it is a meager amount, it is a duty cost upon the decree holder to pay the amount, to show his bona fides, and then he can seek for the execution of the same. As such, this court is not able to appreciate the said submission made on behalf of made by the senior counsel on behalf of the decree holder. Then coming to the contentions and the conduct of the plaintiff, conduct of the defendant. The defendant, who after receiving as the courts have concurrently held that an amount is paid to the plaintiff, the defendant had received the amount and executed the agreement. In such case, after receiving the agreement, after receiving the sale consideration, the plaintiff will execute a registered sale deed in favor of his wife, and the wife in turn to the children. Children in turn will execute the sale deeds in favor of the third parties, and the third parties will come before the court, filing applications, as objectors, filing an application in the execution, and they stall the execution. This, the relief, the specific performance being an equitable relief, the parties, there should be a bona fide action on the part of the party, on the part of the parties who approach the court. When he has nothing to do with the property and when he sold the property by way of several transactions, now in how they are interested with the present suit and how they are filing the applications one after the other shows the conduct of the decree, the judgment at all. In this case, this court is not giving any, is not going into the aspect of whether if there is no, though in this case, this court is not accepting the contention of the decree holder with regard to the timeline that is not fixed in the decree. And once it is not there, they can take their sweet time, but the section 28 application is filed by the judgment debtor. And looking at the amount of 693 and the conduct of the defendant, this court is a view that the defendant, the application that is filed by the petition, the defendant cannot be entertained accordingly. Order in the writ petition as dismissed.
Hello, please. Litigation of 35 years. Both plaintiff and her husband.
But your client also has contributed unfortunately for 500 to 600 rupees. Yes.
My lord, one small submission, my lord. Serial number 35, it got adjourned to 5/3, my lord. Interim order is not extended. Please extend the interim order, my lord.
5/3, that matter.
Much obliged.
Then the presence might have been said not present. He is present and interim order extended.
ನಮ್ದು ಇನ್ನೊಂದು ಇತ್ತಲ್ಲಮ್ಮ 31 ಯಾವಾಗ ಹೋಯ್ತು ಮೇಡಮ್? ಸೇಲ್ ನಂಬರ್ 31.
31 ಅಲ್ಲಿ no representation for respondent.
IO is continued.
This matter on 19th IO extended.
ನಾವು 8 to 10 ಹೇಳಿದ್ದೀವಿ.
31 ಅಲ್ಲಿ
ಹೌದಮ್ಮ? ಹೌದು.
ಅವರು respondent number 1 ವಿವೇಕುಲ್ಲ.
39 madam. 39.
ಆಯ್ತು ಇನ್ನೊಬ್ರು ಪಾಪ ಇವ್ರಿಗೆ ನಾನು ಇದ್ರಲ್ಲ ಪಾಪ ಇವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ, ನಾನು ನನ್ನ ಇಷ್ಟ ಬಂದಂಗೆ ಕೈ ಬೀಸ್ಕೊಂಡ್ರು ಅದು ತಪ್ಪಲ್ವ ನಮ್ದು?
ಚಂದ್ರಶೇಖರ್ ದೊಡ್ಡ ಮೇಡಮ್.
46, 40.
ನೆಟ್ಟಿ ಒಳಗಡೆ
Second list ಅಲ್ಲಿ
ನಾಳೆ ಸಬ್ಮಿಟ್ ಮಾಡೋದು ಇವೆಲ್ಲ
ಆಯ್ತು ಮೇಡಮ್. ಇವಾಗ 47 ಇಂದ ಅಲ್ವಾ? ಆಮೇಲೆ ಲಿಸ್ಟ್ ಆಮೇಲೆ 47 petitioner present, respondent